And how are we doing, peeps? Welcome back to day 5 of the Dead in the Ditch trial. Ivan Bremer, having killed his, we'll call her girlfriend, who also had a daughter who was dating his son, and whose granddaughter was part of the reason that he got turned in. Now, this is day 5. It's a relatively short day in comparison. Days 1 to 4 were more or less opening, closing statements, and then the state case. I can tell you right now, by the end of day 5, we have a verdict. So the defense's case is extraordinarily short, but I'm very interested to see exactly what they actually have to say for themselves and what to argue over. I'm a little bit concerned, because as we knew, as I've said the whole way through this case is pretty well circumstantial. He screwed himself over by shooting himself in the foot and talking during 3 separate interviews, in which he changed his story to fit whatever police were telling him at the time. And he hasn't really made any sort of, he hasn't done himself any favours, basically, is what I'm saying. Now, I'm extraordinarily curious to see what the defence is actually going to say. It seems like they're not going to say very much at all, because a good chunk of today's stream seems to be deliberations. So, but let's get stuck into it, people. Welcome to today's episode of Law, News and Laughter, day 5 of the Ivan Bremer Dead in a Ditch trial. Where's the opener? Where's the opener? Shit. There it is. Alright, and we are back. As the judge would say, we're back on the record. Now, Seta asked whether or not we finished day 4. Yes, we actually did. The stream, for some reason or another, between both Court TV and Law and Crime did cut towards the end. There was 15 minutes where they were sort of talking between themselves, but the audio was pretty crappy anyway, and so we didn't actually miss anything. So we're jumping straight into day 5. I may need to do some lawyering in the interim, but I shall try and keep things moving. And I do need the cut gauge. Shit. Oh, does that really... Oh well. I guess we have to. You gotta do what you gotta do. So, alright, here we go.
We're back on the record after our evening recess. Good morning, ladies and gentlemen. At this point, as I mentioned at the close of yesterday afternoon, you've heard all the evidence and received the exhibits. It's now time for final arguments. But before you hear from the attorneys,
wait, what?
I'm going to instruct you as to the law.
Are they seriously No. Hang on, I need to double check something here. Is he seriously saying that the defense did nothing on day 4 and rested? Is that what got cut off at the end of the stream? Hang on. Yes, Angel, I'll get to you in a second. Hang on. Is that actually what they cut? It can't be. We cannot be on... They cut... No, I don't believe it. Because it goes to a blank screen. And then it's literally... Oh, hang on. Looks like they've appended, 10 minutes. Alright, hang on. We'll see what they have to say for that 10 minutes. And then go from there. Did they seriously... They can't have actually rested, can they?
Apologize.
State wish to be heard.
I think we've made a prima facie case, Your Honor. The 3 counts are murder. Apologize. I think we've made a prima facie case. The 3 counts in this trial have been murder in the 2nd degree. That has 3 elements: that the defendant assaulted Eileen, that she died as a result, and that he did so with malice aforethought. Malice aforethought requires this isn't a first-degree murder charge. We don't have premeditation. It just requires enough time for a person to understand what they're doing. The circumstances of death in this case, Cruz, Bodden, the photographic evidence indicates clearly that Eileen was assaulted. Dr. Bodden opined that she died as a result. The circumstances, especially considering Dr. Bodden's testimony that it would have taken the closing off of her, the compression of her neck for some lengthy period of time, indicates the malice of forethought. This wasn't just a...
Well, see, that's just it. See, what it looks like is that they're resting solely on picking apart the prosecution's witnesses, doing the, basically the bare minimum on cross, and they're just, I mean, to be fair, I suppose, who could they really put on the stand? They're not going to want him to try and get up there and defend himself, but surely they could have found somebody with some form of alibi, even a passerby or a witness to him, like, driving around. No, this isn't the motion to dismiss. This is the prosecution moving for a directed verdict.
Snap decision. This isn't, again, a premeditation case, but we've certainly met the prima facie case on murder second. Count two, abuse of a corpse. We have two elements. We have to provide proof that he either hid or buried or failed to disclose the known location of Eileen, and that's element one. Element two, with the intent to conceal a crime. In this case, the crime being her murder. He clearly, this is not a buried case, but he clearly put her in one location and directed law enforcement to another location. He knew where he had put her.
Yeah, but in this case, I think there's a distinct possibility
that the location when they were looking for her. I believe we've met the prima facie element.
I mean, it still goes to deliberation, but I think that there was a good chance the court may have actually granted
property
this time.
belonging to another, that he intended to permanently deprive the owner, and that the property belonged to Eileen. Then obviously we have to prove the value as well.
I don't think so. I think I think they've done just
we believe
enough.
we've
honestly.
established a prima facie case that he took the safe, contained $1,200 in cash that is supported by the $1,200 cash deposit.
Well, so how's my audio? Because I know that it was down for the previous stream, but the audio seems to be okay today.
He also took whatever other items were in the safe. We certainly have proven a prima facie case to create a jury question on the value, which would go to the degree of theft. The only sort of wrinkle in the case, I think, is the territorial jurisdiction, with the FBI cast agent indicating that, for a 45-minute period of time that the phones showed right around the state line, probably on the Nebraska side. Now I can't remember the code section, of course, but the territorial jurisdiction code section, it's either 8032 or 8023 or whichever one that is, indicates that the state has jurisdiction over any crimes when they occur wholly or partly within the state of Iowa. And the subsection of that is that if one element occurs in Iowa, then the state has jurisdiction. State versus Sarasota, Serrato, which is a Muscatine County case, was a case that the court ultimately found jurisdiction to lie in Iowa, where the only element proven to have occurred in Iowa was the malice aforethought. And that was enough to establish an anchor for criminal prosecution. In this case, of course, it's different. In Sarasota, the body was actually, I believe, found in Illinois, because Muscatine's on the Mississippi River. In this case, Eileen was found in the state of Iowa, and we also have that presumption that's in the law that says that if a murder victim is found in the state of Iowa, then they are presumed to have died in the state of Iowa. And so when you take a look at the territorial jurisdiction, the presumptions, and all the evidence that came in this case, we believe we have met our burden to get this case to the jury. Thank you.
Thank you, counsel. The state has made a prima facie case by presenting sufficient evidence to generate a jury question on each element of each of the three counts. As Mr. Wilbur stated, the count of second-degree murder has three elements. Element one is that there's evidence the defendant assaulted Eileen Gowan. Element two is Eileen Gowan died as a result of being assaulted. And three, defendant acted with malice aforethought, and the court finds sufficient evidence on each one of those elements to generate a jury question. With respect to abuse of the corpse, there is evidence of the two elements required in that count. One, evidence that the corpse was hidden by the defendant, or the defendant failed to inform where the body was, and two, that there was intent to conceal a crime. And finally, with respect to the theft charge, that there's evidence, sufficient evidence to generate a jury question that the defendant took possession or control or property belonging to another, and that the defendant did so with the intent to deprive that person, in this case Eileen Gowan, and that the property at the time of the taking belonged to Eileen Gowan or her estate. Thus, the court finds that that there is a jury question generated on each one of those elements of all three counts. The motion for directed verdict is overruled. Before I bring the jury back, Mr. Munger, obviously when the jury comes back, I'm going to be looking at you and having the defense present their case. There's been some discussion that I've had with you and counsel, and obviously I did not press one way or another until this moment whether or not your client was going to elect to testify.
Oh, fuck, I'm a moron. I keep forgetting that you got to do the motion for directed verdict before the defense starts their case. So it's got... yeah, I know. It sounds like the defense just rested. They didn't provide anything.
If he's not, I would like to make some record now under the presence of the jury, and then we could move forward. If you have any other evidence, fine, but if not, I imagine you'll be resting.
Yes, Judge, we intend to rest, and if the court would like to go over the rights that Mr. Brammer is waiving by not testifying, the court may, or I can do so if the court wishes as well.
Why don't you have a colloquy with your client, because I imagine it's something that you've discussed with him already, and if he'll be familiar with that discussion, and if there's something else I think we need to talk about, I'll do that afterwards.
Thank you, Your Honor. Mr. Brammer, you and I have had conversations about the right to testify in a trial against you, correct?
Right.
And we've had a fair and full discussion about all the pros and cons that would be available to you if you were to choose to testify. Is that correct?
Correct.
And it was also the advice of counsel that you do not testify on your own behalf. Is that correct?
Correct.
And you have been made aware that it is your decision, and it is...
That's interesting. They argued that they advised him not to testify on his own behalf. Yeah, see, here's the thing. He spoke during those police interviews. I'm also wondering exactly how frank and candid he was with his attorneys. As well you should, but at the same time, if you do tell your attorneys certain information, all of a sudden they are unable to provide any sort of affirmative defense. I'm wondering if maybe that's what's happened in this instance. Maybe he was stupid enough to sit down and say, yeah, I did it. And they went, shit. So, It
is your decision alone, and you have been fairly and fully advised of this right, and you are electing not to testify by your own choosing.
Yes.
No further questions, Your Honor.
Thank you, counsel. And I do believe...
See, a good example of this is, did any of you watch the reboot of The Defenders with, I want to say Jim Belushi and, the annoying guy with the short haircut? There's an episode where there's a kid that is accused of raping somebody, and he has an alibi that's one of his friends and all sorts of stuff. And basically, what happened was they, because they specifically found out that he had done it, his lawyers at the time, because they didn't want him to get away with it, which is always horrible. You don't do that. You're always supposed to provide the best representation you can for your client, irrespective of your own feelings on the matter. But basically what they did was they got him on the stand and didn't ask him any questions. A, go and watch The Defenders. I think it's a great show. It's hilarious. B, the fact that they haven't put him up, that they haven't done much, is ringing alarm bells to me. I genuinely think he's sat there at some point and told them that he did it. That's my own personal opinion based on what's happening in court right now. because they are literally not providing any sort of defense, which means they can't. They ethically are bound, and I think that at this point the court and the prosecution probably knows that. I still think there's probably some things they could have done, but either he's outright said to them, I did this, and therefore they can't point the finger, they can't use, again, any sort of affirmative defense. They're sort of bound to rely on the prosecution failing to prove the case as opposed to providing any sort of defense. This is interesting. Like, it's not that this is ineffective counsel. It's literally, it really seems like he hemmed them in. I legitimately think he sat down and the first thing he said to them must have been, I did it. How do we get out of this? And they went, fuck, we can't. So, Harvey Specter says it in Suits. It's literally, what is it? Don't ask the question if somebody, what is it? Don't ask if you killed somebody, but sure as hell find out if there's a smoking gun. Yeah, it's, okay. Alright.
I believe you've covered what I intended to cover in any further colloquy. And Mr. Brammer, just a follow-up, which is just confirming what you've just answered in response to Mr. Munger's question. You believe you've had sufficient time to make that decision after consulting with your counsel, correct? Mm-hmm. Yes? You have to answer out loud.
I can't hear what you're asking me, so can you talk a little louder?
Well, then don't be uh-huh-ing if you can't understand what I'm saying. You've had sufficient time to review the discussion you've had with your attorney on whether or not to testify in this case, have you not?
Yes, I have.
And is it your decision that you not testify?
Yes.
Very well. Any further record by either counsel?
No, Your Honor, I'm satisfied. He knows he's got a right to testify and he has a right not to testify, and it sounds like he's electing not to. We're satisfied.
And again, Mr. Mugger, it's my understanding that the defense has no evidence to present today. Is that right?
That's correct, Your Honor.
Very well. We're going to have the jury back momentarily. When they come back, I will confirm that the state has rested and concluded their case, and then I'll be turning to Mr. Munger and ask if there's any evidence, and you can respond to me at that time. All right?
The judge has literally said the defense is not putting on a case. Fuck! Okay.
Claire, we need a jury.
No, I agree. He is not required to put anything on. It is up to the state to prove their case. However, in this instance, and I've been very critical of the state's case because it's been entirely circumstantial, but to a reasonable person, him sitting there and not providing any defense whatsoever on the basis of what they have provided, I can see how a reasonable juror would come to the conclusion beyond reasonable doubt that he had killed her. I'm not saying that's right, I'm saying that I can understand how a layman would see it that way and why they would come to a guilty verdict. Why didn't he just take a plea? They probably didn't offer one. See you, Seta. Yeah, the judge was not happy. That was funny. Okay, I think that's the lawyering done for the moment, which is good. Defense's job with a guilty client is to monitor the process, ensure the state does not dots the I's and crosses the T's. Yeah, and basically to make sure that they don't cross the line. Pretty much it's literally babysitting. If he has walked in and told them that he's guilty, their job is basically to babysit and make sure that the prosecution doesn't do anything corrupt.
We're back on the
really all
record
that he can do.
after our second recess of the afternoon. Immediately before that most recent recess, the state had concluded its case and rested. I'm now turning to Mr. Munger on behalf of the defendant. Do you have any evidence?
Your Honor, at this time, the defense rests.
The defendant has now rested as well. That means, ladies and gentlemen of the jury, you have heard and received all the evidence. And we're going to take an evening recess. I know it's 3:45 and you're thinking, Judge, we could still work for another 45 minutes. But
He doesn't want them to rush a verdict in 45 minutes. That's
attorney
funny.
well enough, and I don't know if that's sufficient time to take care of summations, and I don't want to keep you here too long. So we're going to recess until tomorrow morning.
Okay, I just want to clarify, the judge did not enunciate properly there. He did not just say, it's not enough time to take care of summations. He said summations, as in closing arguments, the summary. Absolutely nothing, yeah. Like I said, literally having seen this, as we said, the defense is not required to provide any sort of defense. In this case, though, I legitimately think that all they were able to do is try and poke holes in the prosecution's evidence, and that to me speaks louder than a number of things. So, anyway.
And it'll be the same time. If you all could be here at 9 o'clock, I'll try to be in the building at that time as well. And if we can be on the record at 9:15, that's going to be my intent. Please remember that admonition I've given to you. Don't talk about this case. Keep an open mind. And thanks again for not using your cell phones.
Keep an open mind? Are you freaking
recess
kidding
until
me?
9 o'clock.
All rise, please.
In that instance, yes, I did. Okay, so that is what we missed at the end of day 4. I legitimately thought that there was some stuff there that... What was that? Ignore my breaking news. Well, this isn't a breaking news show. This is a replay of a trial, Stingy. Also, I'm not 100% sure. Oh, really? Okay. Are we sure that that's what he meant? He could have had a horrible takeaway? Possibly. I just got that. Damn it. Obviously, no one else witnessed the hose being in the driveway, or they could have used that evidence. Alright, so basically what we have, people, is we have closing arguments, and then we have deliberations, which explains why all of this happened within a single day. So, let's get stuck into it.
Law of this case. And
Oh, hang on, I should probably go back and...
to instruct the jury
There we go.
as to the law prior to your argument, and then I'll introduce you and you'll argue. All right?
Judge, 38, your numbering in the bottom paragraph is instruction 39.
Thank you, counsel.
Oh, what are
All
you
right.
doing?
Anything else before we bring the jury in? Claire?
And Your Honor, Paul will be given the first argument, I'll be giving rebuttal.
Yep.
The judge is like, why are we even wasting our time here?
All rise, please.
We're back on the record
Here we go.
after our evening recess. Good morning, ladies and gentlemen. At this point, as I mentioned at the close of yesterday afternoon, you've heard all the evidence and received the exhibits. It's now time for final arguments. But before you hear from the attorneys, I'm going to instruct you as to the law of this case. And where's Claire? Did she provide you 2 copies? She's been so vigilant and been with me all... Tish, can you see if you can find her?
Seriously?
The record, obviously, with Tish out of the room. But it seems in every trial there's some hiccup. We're we're off the record, obviously, with Tish out of the room. But it seems in every trial there's some hiccups that
Oh, I think that the stenographers left the room. What the hell?
I need to deal with. Members, ladies and gentlemen, I have 6 or 7 copies made, so you'll have to look on by twos. Because how we have you seated.
Well, the other thing, Bart and Bella, it's whether or not they offered him any sort of plea in the first place. Oh, no, now what? Oh. I mean, they may well have thought that they had him dead to rights and not made any... The prosecution is not required to offer a plea.
Thank you, Ms. McDowell. Ladies and gentlemen, I'm about to read to you the instructions as to the law and the verdict forms in this case. Members of the jury, in this case, the court gives you the following instructions. Instruction number 1. The trial information charges the defendant, Ivan Samuel Brammer, with the crimes.
What is going on?
2, 3,
Yeah, they don't
theft
care.
in the second degree.
Prosecution gets paid irrespective.
Count 1, murder in the second degree, includes the lesser crimes of voluntary manslaughter, involuntary manslaughter public offense, involuntary manslaughter conduct likely to cause death or serious injury, assault causing serious injury, assault causing bodily injury, assault. Count 2, abuse of a corpse, does not include lesser crimes. Count 3, theft in the second degree, includes the lesser crimes of theft in the third degree, theft in the fourth degree, and theft in the fifth degree. Instruction number 2.
4 hours?
Trial information is the document that formally charges the defendant with a crime and is merely the method by which the defendant is brought into the court for trial. It is not evidence. Instruction number 3. Ivan Samuel Brammer has entered a plea of not guilty. The plea of not guilty is a complete denial of the charges and places the burden on the state to prove him guilty beyond a reasonable doubt. Whenever I
Which I don't
instruct
think
you,
they did,
the state must
honestly.
prove something. It must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 4. Ivan Samuel Brammer is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant.
Leaf Lover, pretty much everything except criminal, which is ironic, and family law, although it's looking like I may actually move into family law. So, property transactions, commercial litigation, yes, I did actually message you back, so, yep. There's one there. If she's unable to assist, let me know and I'll try and find someone else.
Presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 5. You must determine the defendant's guilt or innocence from the evidence and the law in these instructions. You must consider all of these instructions together. No one instruction includes all of the applicable law. Instruction number 6. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be.
Oh, there you go.
Instruction number 7. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 8. The defendant has been charged with 3 counts. This is just a method for bringing each of the charges to trial. If you find the defendant guilty or not guilty on any one of the 3 counts, you are not to conclude the defendant is guilty or not guilty on the other counts. You must determine whether the defendant is guilty or not guilty.
There's a reason up till now I haven't
separately on each count.
practiced in it, Obama.
Instruction 9. You shall base your verdict only upon the evidence in these instructions. Evidence is testimony in person or by deposition. Exhibits received by the court. You may examine exhibits closely, but be careful not to alter or destroy them. Stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witness depositions, or other miscellaneous items. Only those things formally offered
I think
and
they're just
received
winging
by
it.
the
I don't think
court
there was
are
much they
available
had
to
to talk
you
about at
during
all.
your deliberations. Documents or items read from or referred to, which were not offered and received into evidence, are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers, objections and rulings on objections, testimony I have told you to disregard, anything you saw or heard about this case outside of the courtroom. Instruction number 10. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 11. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of the witness testimony. There are many factors which you may consider in deciding what testimony to believe. For example, whether testimony is reasonable and consistent with other evidence which you believe. Whether a witness has made an inconsistent statement. The witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. The witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 12. Statements and questions by law enforcement officers and other investigators during interviews with the defendant are not evidence to be considered for their truth. The defendant's answers and responses to those questions and statements are evidence. Instruction number 13. Evidence has been offered to show Ivan Samuel Brammer made statements at an earlier time and place while not under oath. These statements are called admissions. You may consider an admission for any purpose. Instruction number 14. In this case, the defendant decided not to testify. The defendant is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains upon the state to prove the guilt of the defendant. Instruction number 15. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. Instruction number 16. The burden is on the state to prove Ivan Samuel Brammer guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence, or lack of evidence, produced by the state. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt, and you should find the defendant guilty. But if after a full and fair consideration of all the evidence, or lack of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt, and you should find the defendant not guilty. Instruction number 17. When two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which is based. Instruction number 18. To commit a crime, a person must intend to do an act which is against the law. While it's not necessary that a person knows the act is against the law, it is necessary that the person is aware he was doing the act, and he did it voluntarily, not by mistake or accident. You may, but are not required to infer, a person intends the natural results of his acts. Instruction number 19. A person is subject to prosecution in this state for an offense which the person commits within or outside the state by the person's own conduct or that of another for which the person is accountable if
This is
one,
actually 4
the
days
offense
ago,
is committed
Jason.
either wholly or partly within the state.
The trial ended
Two,
very abruptly.
An offense may be committed partly within
I
the
just didn't get a
state
chance
if
to,
conduct which
stream
is
it.
an element of the offense or a result which constitutes an element of the offense occurs within the state. If the body of a murder victim is found within the state, the death is presumed to have occurred within the state. Instruction number 20. A person participates in a crime beginning with the first act done toward the commission of the crime and ending when a person has been arrested or has escaped from pursuers. A person participates in a crime regardless if he is successful in committing it. Instruction number 21. Under count 1, the state must prove all of the following elements of murder in the second degree. 1. On or about the 13th day of February 2023, the defendant assaulted Eileen Gowan. 2. Eileen Gowan died as a result of being assaulted. 3. The defendant acted with malice aforethought. If the state has proved all of the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree. And you will then consider the charge of voluntary manslaughter explained in instruction number 24. Instruction number 22. Murder in the second degree does not require a specific intent to kill another person. Instruction number 23. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or designed to do some physical harm to another.
What's ironic is this is already at 1.25
It does not have to exist for any particular length of time. Instruction number 24. The state must prove all the following elements of voluntary manslaughter. 1. On or about the 13th day of February 2023, the defendant intentionally assaulted Eileen Gowan. 2. Eileen Gowan died as a result of being assaulted. 3. The assault was done solely by reason of sudden, violent, irresistible passion resulting from serious provocation. If the state has proved all of the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you will then consider the charge of involuntary manslaughter public offense explained in instruction number 26. Instruction number 25. A serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his passion under control and suppress the impulse to kill. Words alone, however abusive or insulting, cannot be serious provocation. Instruction number 26. The state must prove both of the following elements of involuntary manslaughter, public offense. 1. On or about the 13th day of February 2023, the defendant recklessly committed the crime of assault. 2. When the defendant committed the crime, the defendant unintentionally caused the death of Eileen Gowan. If the state has proved both the elements, the defendant is guilty of involuntary manslaughter, public offense. If the state has failed to prove either of the elements, the defendant is not guilty of involuntary manslaughter, public offense, and you will then consider the charge of involuntary manslaughter, conduct likely to cause death or serious injury, explained in instruction number 27. Instruction number 27. The state must prove all of the following elements of the crime of involuntary manslaughter, conduct likely to cause death or serious injury. 1. On or about the 13th day of February 2023, the
I'm
defendant
still hoping I
recklessly
can
assaulted Eileen
twist Nick's
Gowan.
arm to help me get a signed
2.
copy.
The defendant did the act in a manner likely to cause death or serious injury. 3. By doing the act, the defendant unintentionally caused the death of Eileen Gowan. If the state has proved all of the elements, the defendant is guilty of involuntary manslaughter, conduct likely to cause death or serious injury. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter, conduct likely to cause death or serious injury, and you will then consider the charge of assault causing serious injury explained in instruction number 29. Instruction number 28. A person is reckless or acts recklessly when he willfully disregards the safety of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences. For recklessness to exist, the act must be highly dangerous. In addition, the danger must be so obvious that the actor knows or should reasonably foresee that harm will more likely than not result from the act. Though recklessness is willful, it is not intentional in the sense that harm is intended to result. Instruction number 29. The state must prove all the following elements of assault causing serious injury. On or about the 13th day of February 2023, the defendant did an act which was intended to cause pain or injury, or result in physical
Bella, I'm willing to
contact
bet
which
that
was
there'll be a,
insulting or
sequel.
offensive, or placed Eileen Gowan in fear of immediate physical contact, which would have been painful, injurious, insulting, or offensive to her. 2. The defendant had the apparent ability to do the act. 3. The defendant caused a serious injury to Eileen Gowan. If the state has proved all of the elements, the defendant is guilty of assault causing serious injury. If the state has failed to prove any one of the elements, the defendant is not guilty of assault causing serious injury, and you will then consider the charge of assault causing bodily injury explained in instruction number 30. Instruction number 30. The state must prove all the following elements of assault causing bodily injury. On or about the 13th day of February 2023, the defendant did an act which was intended to cause pain or injury or result in physical contact, which was insulting or offensive, or placed Eileen Gowan in fear of an immediate physical contact, which would have been painful, injurious, insulting, or offensive to her. 2. The defendant had the apparent ability to do the act. 3. The defendant caused bodily injury to Eileen Gowan. If the state has proved all of the elements, the defendant is guilty of assault causing bodily injury. If the state has failed to prove any one of the elements, the defendant is not guilty of assault causing bodily injury, and you will then consider the charge of assault, as explained in instruction number 31. Instruction number 31. The state must prove both of the following elements of the crime of assault. 1. On or about the 13th day of February 2023, the defendant did an act which was intended to cause pain or injury or result in physical contact, which was insulting or offensive, or placed Eileen Gowan in fear of an immediate physical contact, which would have been painful, injurious, insulting, or offensive to her. 2. The defendant had the apparent ability to do the act. If the state has proved both of the elements, the defendant is guilty of assault. If the state has failed to prove either of the elements, the defendant is not guilty. Instruction number 32. A serious injury is a disabling mental illness or condition which cripples, incapacitates, weakens, or destroys a person's normal mental functions, or bodily injury which creates a substantial risk of death, or which causes serious permanent disfigurement or extended loss or impairment of the function of any bodily part or organ. Instruction number 33. The term bodily injury means physical pain, illness, or any impairment of physical condition. Instruction number 34. Apparent ability means a reasonable person in the defendant's position would expect the act to be completed under the existing facts and circumstances. Instruction number 35. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 36. An assault is committed when a person does an act which is meant to cause pain or injury, or result in physical contact which will be insulting or offensive, or place another person in fear of immediate physical contact which would be painful, injurious, insulting, or offensive to
Oh
another
shit,
person.
Jude dropping
when
5
coupled with
memberships.
the
Thank you,
apparent
Jude. Very
ability
much
to do
appreciate
that.
it.
Instruction number 37. Under
So
count
you have an
2,
issue with an
the state
apostrophe,
must prove
seriously?
all of the following elements of abuse of a corpse. 1. On or about the 13th day of February 2023, the defendant either A. hid or buried a human corpse, or B. failed to disclose the location of a human corpse. 2. The defendant hid, buried, or failed to disclose the known location of the human corpse with the intent to conceal a crime. If the state has proved both of the elements, the defendant is guilty of abuse of a corpse. If the state has failed to prove either of the elements, the defendant is not guilty of abuse of a corpse.
Look at that green in chat.
Instruction
Thank
number
you, Jude.
38. Under count 3, the state must prove all the following elements of the crime of theft. 1. On or about the 13th day of February 2023, the defendant took possession or control of property belonging to another. 2. The defendant did so with the intent to deprive the other of the property. 3. The property at the time of the taking belonged to Eileen Gowan or Eileen Gowan's estate. If the state
I'll
has
be
proved
damned.
all the elements, the defendant
StreamYard
is
is
guilty.
now starring
You must
membership.
then determine the
things.
theft, the degree of
Lovely.
theft, as explained in instruction number 39. If the state has failed to prove
Good God, at this point, man, you're going to spend more time on jury instructions than they do on deliberations. What the fuck? Okay.
any of the elements, the defendant is not guilty. Instruction number 39. If you find the defendant guilty
Until I
of
get to
theft,
deliberations.
you should then determine the
Oh
degree
no,
of
still
theft.
got fucking...
I've attached a question as part of the verdict
Oh,
form,
there's
which
another
must
7
be
minutes of
answered,
this.
and by
Alright,
so
chat,
doing,
throw
you will
ones in
determine
chat
the
if you want me to
degree
move
of
ahead to
theft.
closings.
In answering the
This is doing my
question,
head
the state must prove the value of the property taken. You will check the blank next to the appropriate value on the verdict form. The following are the different degrees of theft. Property valued $300 or less is fifth degree theft. Property valued more than $300 but not more than $750 is fourth-degree theft. Property valued more than $750 but not more than $1,500 is third-degree theft.
Alright,
Property
well, we got
valued more
3
than
out of 53 if
$1,500
he's
but
watching
not
on
more than
YouTube.
$10,000 is second-degree theft. Instruction number 40. During the trial, you've been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Taking them, leave the notes in your Snapchat, search, or make it in YouTube, Twitter,
Wait, what was that?
media such as text messages, Facebook, Snapchat, LinkedIn, YouTube, Twitter, email, etc.
I love that they have
Do
to
not do
specify
any
about
research
us.
or make any investigation about this case on your own. Use Internet Maps or Google Earth or any other program or device to search for or to view any place discussed in the testimony. Involves using the right on matters not presented in court. Has been not know about information, and you must conduct yourself so as to maintain the integrity of the trial process. If you decide a case based on information not presented in court, you will have denied the parties a fair trial in accordance with the rules of this state, and you will have done an injustice. Failure to follow these instructions may result in the case having to be retried and could result in you being held in contempt and punished. Instruction number 42.
Oh my
Be
God.
and freely discussed. Even if you have a verbal do, you 1 through 8, and then B, there's 2 other forms of verdict. Only one of those would be used. Ladies and gentlemen, I've instructed you as to the law of this case. It's now time for summations, or what's often called final arguments from the attorneys. The state will have an opportunity to address you first, followed by an attorney from the defense, and then the state will have an opportunity for rebuttal. Their summations, or final arguments, will summarize the evidence, and they'll be recollecting evidence that you will later on in as part of your deliberation. They're not going to be trying to mislead you, but if your recollection of the evidence is different than theirs, you need to rely on your own recollection of the evidence. Again, their statements or summations are not evidence, they're arguments. But it's important that you give them your full attention because their arguments are an effort.
He is, and I'm not going
by
to bag
each
him for
party
that. I just
to
think he
present
could
their
have
position
gotten through those
on each of
jury
these three
instructions a
counts.
little bit
I'd ask you to
simpler and
give them
easier.
your full attention.
I mean, I know that they're
Mr. Forney,
formatted and
counsel.
what do you call it? They're form things that you just got to go through. But all right, here we go, dude. Talking to the freaking microphone. We just sat through that, and you're not even gonna. Screw you. Motherfucker ain't even close enough to get captions. Are you serious right now?
The story really began on February 13th, 2023. But it actually begins a few years before that.
Speaking of contempt. Yeah, Tobias, closing arguments. The state rested without providing any sort of case whatsoever. What the f...
The fact that there was no relationship between the two. It didn't matter. The bid couldn't accept it. Did not have control. In fact, Eileen. She wasn't
Yes, I
pregnant.
did expect something else.
There's no evidence of alcohol. She stopped drinking. She had money that she earned because she was working hard. And she was trying to find a place for herself. She trusted the defendants, even though they were no longer saying she trusted the defendants because they had known each other for a year and a half to 2 years. So that morning,
Yeah, I think we
on
should
February
change the
13th, 2023, exciting now, I'm sure. Drives off at 8:32 a.m. Eileen had no idea what this was. At some point, the defendant lost it. Tragically, Eileen lost her life
No, the defense rested without providing any case. It went straight from the state applying for a directed verdict to that being denied
Just went
to
through
the
all
state
the,
resting.
all the
And that's how day 4
instructions,
apparently
and that was a lot.
That was the last 5 minutes we were missing off the end of the screen.
What I would like to do is just talk about a few of the instructions and highlight a few. First of all, in considering the evidence, you will make deductions and you'll reach conclusions according to reason and common sense. Use your common sense. You all have it. All your experiences that you've had in life, you will be able to use your common sense in this case. Instruction number 16, I'm not going to read this. This is the state's burden. The state has the burden of proof to prove the defendant guilty beyond a reasonable doubt. You have the instruction. What that really means is if the state, if you're firmly convinced that we proved our case in murder in the second degree, then there's no
Objection.
reason to doubt. You're firmly convinced. Instruction number 21. This is where we get into marshalling instructions. And Mr. Wilbur talked to you about checklists. This is where you have to use the checklist. This is where you have to look at the elements of a crime. We have 3 different offenses. The first, count 1. The state must prove all the following elements of murder in the second degree. On or about the 13th day of February 2023, the defendant assaulted Island County. The state proved that. 33 injuries on her body. Eileen Gowan died as a result of the assault. And the defendant acted with malice aforethought. We'll get into malice aforethought. But here is the thing. If you believe Dr. Overlaw'd's opinion,
I'm sorry, did you see those? Dr. Biden Laden. You can't make this shit up. Like, that was funny. If the defense didn't even make a case, then I think he will fry. I'd be surprised if he gets off. Tobias, we already know the result of this. This was from Friday. I just didn't get a chance to stream it. For those of you that are coming in after having missed what happened at the start of the stream, watching the last 5-10 minutes of day 5, I legitimately think at some point he was stupid enough to tell his lawyer specifically that he did it and that he was guilty. The fact that they did not put on any case whatsoever tells me they were not allowed to put on any sort of affirmative defense, which means that they've had their hands tied. Because even in a case like this, where it's all circumstantial, they could have found something. There could have been something. Even if it was an expert to say that he was in some sort of mental distress or some shit like that, you would still put something in there. The fact that they rested without providing anything tells me their hands were tied. At least that's how it would be here anyway. As a jury, you'd be pretty confused. Yeah, that's understandable. It's a messed up situation, and this is a guy that is going to fry on the basis of very circumstantial evidence that was provided by the state. I'm gonna be interested to... Yeah, okay.
that she was assaulted, and that coat was grabbed and twisted up and choked her. Neck compression. And it was held there. And he's guilty. of murder in the second
Yes.
degree. Those elements.
It's the paramount duty of the court. You can't mislead the court. You can't
Excuse me,
mislead...
Mr. Forney, and I apologize for doing this. We got a full courtroom, and I think you need to keep your voice up because of the media and just try to keep your voice a little louder.
On
Make
you,
sure,
Judge.
Mr. Reedy, as well as other folks in the county, have the best hearing can hear you. I don't know if I don't think that mic stretches over this.
I'll speak louder.
Thank you, I appreciate it. I apologize for interrupting you.
Instruction number 22. Murder in the second degree does not require specific intent to kill another person. Malice? What is malice? It's a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. Is assaulting unlawful? choke and lost.
Well, that's just it, onion bitterness. I mean, the original coroner basically couldn't
It may be found from the
definitively
acts
say
and
cause
conduct
of
of
death
the
or even
defendants.
rule it a homicide. They're relying on Dr. Barden.
That we've proven in this case.
Just gonna
And the
call
means used in doing the wrongful and injurious act. 33 injuries. 33 injuries. Malice, a 4-5. This is not a first-degree murder case. The state does not have to prove premeditation. Malice, a 4-5, is a fixed purpose or designed to do some physical harm to another which exists before the act is committed. So it's not a reflexive, it's not something like a reflex. There's got to be a thought, but it doesn't have to be long. But if you believe the opinion of Dr. Barden, that jacket was twisted up. She's been assaulted, or is being assaulted, all the injuries. That coat's being twisted up, and it's being held there. And it's being held there for probably at least a minute. If you
Yeah,
believe
see, that doesn't make any sense to me. While he's driving,
then you
he's
have
supposedly
malice
reached over,
aforethought.
pulled up her jacket to the point where it's choking her, or preventing her from breathing or
Instruction
whatever for
goes
over a minute.
This is the abuse of a corpse. On or about the 13th day of February 2023, the defendant either hid or buried a human corpse, or failed to disclose the known location of a human corpse. The defendant dumped Eileen's body in a ditch in a remote location where not likely to be found for a while. And at the same time, the entire time that law enforcement, friends, and family are searching for his body, or her body, he is lying to law enforcement. He is not helping them find her. He's doing the exact opposite. He's throwing off the scent. He's making it more difficult to find Eileen. Instruction number 38. The state must prove all the elements of theft. From a theft standpoint, it's really going to be up to you what you decide the amount is. If we've met all the elements, you look at the amount. And the state believes that it's true in this case. The defendant took a safe. The safe has a value. $1,200 in the safe. Other contents in the safe. Purse is gone. Phone's gone. Is that,
Not the
is that more than $1,500, but not more than $10,000? If it is, and you are the ones that decide. If it is, then that's theft in the second degree. If it's not, and you say it's, well, maybe I think it's more like 1,000. That's theft in the third degree. You are the ones that will have to make that decision based on the evidence that was presented.
Yeah. What I think the trouble that you're not understanding Amazing Disgrace is, and again, this is exactly why I think he specifically told his lawyers that he did it, is because if they know he did it, all they can do is poke holes in the prosecution's case. They can't point the finger at anybody else. They can't explain away why he may not have done it. There's a whole... He basically, in my opinion, what he has done at some point is he has walked in, he has told those defense attorneys that he did it, and as a result of that, not only has he tied one hand behind their back in order to defend him, he's tied both. Particularly if because of the nature of this case, there's no one else involved. There's very little in terms of exculpatory evidence to say that he was in another area or something like that. But even if that were the case, they couldn't use it. Specifically, if he's told them that he did it. That's why it's a fucking messed up thing, because the whole point of the process is to make sure that guilty people go to jail. You walk in and tell your lawyer that you've killed somebody. They can't actively make it look like you didn't. They can't actively make it look like somebody else committed the crime. They can't point the finger in other people's directions. That is purely what has made me think that at some point he has been dumb enough to walk in and talk to those lawyers and say, yes, I did it. Now get me out of this. So, it's not about whether or not they're providing a vigorous defense. It's literally, ethically, and under the rules of the court, they can't if he has hamstrung them in that way. So that's really what's ringing the alarm bells for me, because it's literally, lawyer cannot lie to the court on behalf of the client. No, of course. I saw Dr. Barden's testimony. In my opinion, it looked like the doctor was mentally flustered and doddering. fixated on towing the prosecution's narrative. Yeah, and look, I wasn't particularly pleased with some of the things that he said, the way that he went about the testimony, the way that he like, even the reading the article and saying, oh, am I supposed to be reading this out or whatever, I think he's well and truly past his prime in terms of providing evidence in cases. Now, I know that there's people out there that absolutely love him and all that sort of stuff. This is my first time actually seeing him on the stand, so this is sort of like, from my perspective, this is seeing Schrader in Anderson before going and watching... No, the defense did not hire Barden. The prosecution did, or the family of the prosecution did. What was I trying to say? This for me. This is like seeing Schrader in Anderson before seeing him in Rittenhouse, when everyone had the jadedness and the rose-tinted glasses on about him. So, I mean, he seemed more concerned with his own reputation. Yeah, I like him, especially back in his day, but he agrees with whoever signs his check. Yeah. You sort of expect that from experts. Actually, I saw a really good tweet. What was it? 9 out of 10 experts agree with whoever's writing their check, and the other 1 out of 10's been banned from Twitter.
Instruction 19. I'm just going to highlight the last line. Last sentence. If the body of a murder victim is found within the state, the death is presumed to have occurred within the state. The body was found.
They're actually that convinced that they've got him dead to rights, that they're making sure that the jury knows over the jurisdiction issue. Like...
Instruction 13. Evidence has been offered to show the defendant made statements at an earlier time and place while not under oath. You saw interviews. You saw videos. You saw a video from February 15th with Sergeant Roberts and Detective Dyer. Roberts conducted the interview. You saw that interview. That's in evidence. You saw another interview from February 17th where Sergeant Roberts and Detective Brannigan interviewed the defendant. There were statements the defendant made there as well. You saw that. That's evidence. There were statements that the defendant made at the welfare check. When Officer Boldra did a welfare check with the defendant, and again, made statements, you have that evidence, that video. Now, you may consider any omission for any purpose, like credibility, right? So, in the first interview on February 15th with Sergeant Roberts, he says, I picked her up from Sugar's at 8:30. I took her to Mike Robbins' house. Then I went back to my apartment. Sometime later, I hear knocking on my window. I think it's her. February 17th, story changes. Sergeant Roberts followed up on that. And Sergeant Roberts figured out he didn't go straight to Mike Rockman's house. No, he must have taken a different route because the video evidence shows something different. Well, February 17th, story changes. Credibility, story changes. It's a mission of the defendant. Now, the defendant picks up Eileen, 8:30, leaves at 8:32. Doesn't go directly to Mike Rockman's house. Instead,
yeah,
the false
authority is just ridiculous sometimes.
Eileen had to pick up a save. Then after we did all that, I took her back to Mike Rockman's house. Dropped her off, never saw her again. Oh, I get a knock on the window. I think it might be her. We did get video evidence from Dudley Court, so now we know they actually did go to Dudley Court. And they also went to Sherwood Apartments to see if she could rent a place. Story number 3. At this time, witnesses have testified that now we know that the defendant has gone into Omaha. We know he's going that direction.
Oh, good, he's alive. I was worried that guy was about to have a heart attack and fall asleep or something.
He's confronted about it. Did you go to Omaha? No, I don't remember going to Omaha. Then later, yes, went to Omaha. Went to Omaha. Went to go get cigarettes. Went to Carter Lake to fool around. Then I took her back to my Rockman's house. Dropped her off. Never saw her again. She came knocking on my window. Story changed again.
Oh yeah, I should clarify that. I deleted the family twig, but it's literally she was dating him, his son was dating her daughter, and they both have kids. And then so yeah, like the victim's family is literally his family. So it's more or less the same thing, but it's everyone in his family is pissed off and thinks that he did it. So yeah, it's break out the banjo basically. I still can't understand how that. Anyway,
Those admissions, those you can consider that for any purpose in this case. Let's talk about some of the witnesses that did testify in court over this last week. Nicole Shipman. Nicole, she is the daughter of Eileen. Nicole last spoke with her mom at 8:06 a.m. while her mom was at Shooters.
yeah,
Her mom had just finished her cleaning shift.
dude, are you
This
really
is
gonna
on
try and
February
do this without a
13th,
family twig on
2023.
the screen? You're gonna confuse the jury.
Always keeps in contact with her mom. She has great communication with her mom. Didn't have any communication with her later that day, and something wasn't right, because that's not like her mom. On the 14th,
What are
she
you
reports
doing,
her missing.
step bro?
She said, I've got to go with the law enforcement. We've got to report this. Report is made on February 14th. The defendant and Eileen also both lived with Nicole. So Nicole knows that relationship very well. And I believe she talked about it being an off and on again. It was unhealthy, but she knew the relationship well. She also witnessed her mom accessing her safe. And that's important because she testifies about the safe, but she testifies about how her mom opens the safe. It's a key. It's not a combination, it's a key. She uses a key to open up that safe, which is important detail. And she also talks about Eileen when she went to go purchase a diamond stud earring. And that diamond stud earring was for the defendant. It was similar. There's the diamond stud earring. 17. We'll come back to another slide, but with Justin Brammer is the son of the defendant. Justin Brammer also happens to be in a relationship with Nicole, so they live together. Justin had some important testimony. He did talk about the fact that his dad told him the story about picking Eileen up from Sugars and driving straight to Mike Rothman's house. So that corroborates some of the evidence that you've heard. He also talked about the defendant not dropping Eileen off in the driveway because some black hose was in the driveway. But what he also testified to was the fact that although he has his dad's tools and stores them, and now he considers them his, Justin, he never sold his dad's tools and never gave his dad money for selling those tools. $225. The defendant takes that sentimental earring while Eileen is missing and pawns it for $160. Emily Brammer testified.
There you go.
Emily
Put it in
is the
memes.
granddaughter of the defendant. The defendant and Eileen at one time lived with her at Cottonwood Apartments. The defendant and Eileen broke up. Eileen moved out. It was just the defendant and Emily in Cottonwood Apartments. So the defendant and his granddaughter are living at Cottonwood Apartments. She testified that when they broke up this time, it was fine. That was it. It was fine. She also testified that when Eileen was missing, she saw the defendant with Eileen's phone. And she described the phone with a pink case, and she further stated that she knew that phone because she had held that phone before in her hand.
Still kind of feel like the
Also
phone
told
should have been
him,
into
his
this
own
evidence.
granddaughter, to lie to law enforcement if they asked her about crushing the truck. She testified about some of the behavior of the defendant during the period that Eileen was missing. He was angrier. He drank more. He lost weight. He quit his job. And she called in the welfare check because the defendant was making suicidal statements and she was concerned about her grandmother. Officer Baldwin was the officer that went and did the welfare check, and you saw that video.
Come on, say it. Say the
What's interesting
bullshit. Say
about
the
that
bullshit.
A few things, but the most interesting thing about that video is the fact that the defendant talks about Eileen being raped on February 10th, which was the Friday before she went missing. And yet, his story is that on Monday, he went and dropped Eileen off at Mike Brockman's house, the supposed individual that raped her.
Just remember, peeps, we're still $25 from Doggo Cam too. Because I do count memberships, so thank you very much, Jude, for putting us halfway to seeing a beautiful blonde on screen.
You talked to my phone. My name's Sam Robertson.
Wait,
Sorry.
what?
I'm the last person in your life. I didn't say that. I didn't say that. I said you're the last person that saw her before she went missing. So that's why it was important for us to talk to you.
That's some BS. The state's already arrested. They shouldn't be playing that again. Oh, look, and someone's got an email. Oh, excuse me.
Megan Preston testified. Megan Preston is the owner of Sugars. Sugars is a restaurant bar that is 2.5 miles away from Mike Brockman's house. Sugars is the place where the defendant worked. Eileen worked there as well. And even Mike Brockman
Very
was
bad
a
interviewer.
person that went there and drank sometimes. What Megan testified to was that Eileen came and worked her shift that morning, February 13th, 2023, and she did a good job. There was no issues with the shift. She had no observations of Eileen being anything with her. She states that she's a reliable worker and she's a good communicator. There was a message, and this is in evidence, Exhibit 16, from approximately 2:44 p.m. Megan, who has Eileen in her phone as Eileen Clean Lady, Megan worked that shift and she was ready to go home. And Eileen was supposed to show up at 2 o'clock for her shift, but she never showed. So she's sending messages. She's trying to find where Eileen is because she needs Eileen to come in. At 2:20, she sends a text message to Eileen saying, "Where are you?" And the response back comes at 2:44, "I'm done, leave me alone." She testified that that's all. That's kind of response. Sam Brammers communicated with Megan as well on Exhibit 16B. Again, Megan's trying to figure out where is Eileen. February 13th at 2:30, Megan sends a message to Sam Brammer, Facebook Messenger. "You don't have to respond, but I was wondering if you knew where Eileen was." His response back, "No, ma'am. She texted me. Sounds like she was drunk." Megan also provided video for us. She testified to that. She provided video that shows the defendant pulling up to Sugars and Eileen leaving with the defendant at 8:32 a.m. in the morning. She also provided video that shows Eileen walking in at around 8:30 into the entrance of Sugars, and she seemed to appear to be walking normally. She also provided video of Mike Brockman coming down later at night and dropping off Eileen's belongings, just like he testified to. Megan also testified about something that was a little odd, and that was that on 2/16, when the defendant was supposed to work his shift, that he was just sitting out in his truck in the parking lot, or in a vehicle in the parking lot. And he was supposed to be working his shift. And he never does come in and work the shift. Mike Brockman testified. Mike Brockman, straight shooter. He said he allowed her to stay a couple days. Videos from shooters corroborate his story. Everything that he said is corroborated. Dropped her off in the morning. She worked her cleaning shift. She was supposed to come back and pick her stuff up. She never did. Mike Brockman worked a full day of work on 2/13. Worked a full day of work on 2/14 as well. Mike Brockman was interviewed by law enforcement. His phone was dumped by law enforcement. And his appointment was verified. His boss, Marcia Del Hoy, came in and testified to Mike Brockman working those 2 days. And moreover, she testified that when he would run to go get parts, that he would only be gone for 30, 40 minutes at a time. Mike Brockman had no relationship with Eileen. He was just helping her. Carol Martin is Mike Brockman's landlord. She lives 2.5 miles away from Sugars out on Railroad Highway. She lives on a small little farm. She's got horse stables there. Mike Brockman rents the bottom space of her house. He has his own entrance in the back, like she testified to. First of all, she had no idea about a black hose in the driveway. There was never a black hose in the driveway. And she also said that when strangers come to her property, her dogs bark. And she was there in the morning on February 13th, 2023. The defendant is saying that he's dropping Eileen off at Mike Brockman's house that morning. This evidence is to the contrary. Sergeant Roberts. Sergeant Roberts was the lead investigator in the missing persons case. It started off as a missing persons. And he was the one that first spoke with the defendant. He was the one that was following up on the report that Nicole had made. My mom was missing. He interviews the defendant on 2/15, which is less than 2 days from when she goes missing. And
Yeah, February this year.
when he interviews
Damn quick.
the defendant, there's a portion of that very beginning of that video where the defendant comes in and tries to say that the officer, Sergeant Roberts, said that he was the last person to see her alive.
This started me talking on the phone. My name's Ted Roberts. I'm sorry.
I was the last person to see her alive.
I didn't say that.
Yep.
I didn't say that.
Yes, you did.
Yeah.
Yes, you did.
I said you're the last person that saw her before she went missing.
Last person to see her alive. It's been gone for 2 days. The defendant is saying that because he knows he's already murdered her. No one else is talking about alive after 2 days. Use your common sense. We don't think someone's dead after 2 days.
If you could,
I don't like
I just
that.
need to know what went on Monday morning. What happened Monday morning with you?
She's acting.
Okay.
And want to know if I would come get her, because one of her friends was supposed to come and get her. And both of them are out of gas. So,
Did she tell you the friend's name? Or? Okay.
they should have to have her names anyway. Half the people were not to have her names, so I gave them. Like it's my girl told me that I don't forget her. And then, maybe another person I'm back in the kitchen. I call her Pamela Miller. Those are two that she was very afraid of. Those two.
Okay.
So I got there, and I said, I'll be there in a minute. She was going to come inside. I don't want Megan to know that we're back, or you're with me. I said, okay. And I pulled up, she was in the truck. We came out, ran out to this. You know the guy's name now? Those are the one that tried to do something with her. And dropped her off there. And I left. And then, like 2 months after
one thing. Okay.
And I'm sure not, I'll shoot just saying as he did. We get her, I don't know.
Then it says, he drops her off at my Rogers. Goes back to his apartment. And then he receives a text from Eileen. A text from Eileen. Eileen is somewhere else. He's at his apartment. We'll come back to that. Sergeant Roberts followed up and realized that this isn't anything. He was like an interview or something, not like this. Not trying to corroborate his story, and videos aren't corroborating the story. Detective Dyer, he was part of this interview. Detective Dyer, I don't recall him asking a single question. He was there, but Detective Dyer came in and testified. Detective Dyer went and picked up the defendant and brought him to the station to do the interview on February 15th, clip that you just saw. And after the interview was over, Detective Dyer takes the defendant back.
That's the other reason I'm thinking that he actually told his lawyers that he was guilty.
Where he lives, his apartment. And one thing that Detective Dyer notices that caused attention is that the defendant, when he gets out, he walks directly over to the dumpster and just looks into it and then walks away. When you start looking at some of the other evidence that you've seen in this trial, where you saw the video of the defendant coming back from Trainer, going straight to his apartment on February 13th, rides around 1 o'clock, gets out his truck, and starts taking stuff over to the dumpster, putting stuff in the dumpster. This is 2 days later. The defendant's checking to see if that stuff is still in the dumpster.
This is why you don't
Detective Ron
return
Brannigan. We had a lot of testimony from Ron Brannigan. He ended up being the lead detective in this case. What Ron really did is he gave us the timeline. He tracked the defendant's truck, and we learned about the movements of the defendant with Eileen on February 13th. And pretty much through video, through intersection cameras, through private businesses, track the movements for the day, which also tell a different story than what the defendant had told law enforcement 3 different times. What we do know, and what you have as evidence, is that after leaving Sugar's at 8:32 a.m. with Eileen, and we have an exhibit where Eileen's in the truck and you can see her at 8:32 a.m. Law enforcement tracked the defendant's truck movements, and we know at approximately 9:28 a.m., instead of the defendant's vehicle going up to Mike Brockman's house, what we know is that after Dudley Courts, that this vehicle is heading towards Omaha. And this is at 9:28. So the vehicle's going westbound. And there's a gap there. There's about a 58-minute gap where we don't know. We don't know exactly. We don't have any surveillance. So we don't know exactly where he's at in the vehicle. But we know Eileen's with him when he's going that direction. And we also know that from Dudley Court's videos, you see her walking through in the entrance up to her mom's apartment, down the hallway, back down the hallway again, and out of the building, and was alive and was walking just fine. You saw that with your own eyes in the video. And she was carrying a black safe.
This guy needs to learn how to be more concise.
What we also know, and what you saw as evidence, is you saw the defendant's vehicle come back in Council Bluffs at 10:26 a.m. And we had some images where it appears it's Eileen in the passenger side, but those images were hard to get a lot of detail from, but you could tell someone's in there. And what we also know is that at 10:30 a.m., the defendant goes through Burger King drive-thru. And you have a video of that. And you see the video. And we have a couple photos that are
Oh, what are we looking at?
as well. And you can see
40
that
odd
as well.
minutes?
And
30,
the entire
40,
video,
yeah, almost on the
it's not a
dot.
long clip. but it's long enough to see the defendant.
Where's
exchanging
Judge Escarati when you need her? Telling him to
with,
keep to
the
his time or
individual
whatever.
working for Burger King. But when you focus on Eileen, she doesn't move
Because we've still got the defense closing, and then we've got
Not
state's rebuttal.
at all. And the only thing you can see moving
Not
in
that I'm
that
expecting
video
much from the defense, if I'm
is
honest.
two
but,
things.
You know,
Defendant moving his arm out to exchange with the teller in the window, but you can see his chest and his body pounding through his chest. You can see it in the video. He has already assaulted her. He doesn't know what to do with her. And then, of course, we've got the defendant eastbound heading out to Trainer, 14 miles away from Council Bluffs. And we know he's out there because we have video of it. Have him going out
Yep.
and have him coming back. Never in any of the stories of the law enforcement going to Trainer. Not once. In fact, when he's confronted about it, didn't have an explanation for it.
oh
The
good, so
story
it wasn't just
was
me getting
conforming
excited when he mentioned Burger
as
King.
law enforcement
Yes, I admit
confronted
I'm
the
that.
defendant
I don't
about
care.
some of the other surveillance footages and knowing his location, his story kind of changes to conform with it. Like, for instance, I wasn't in Omaha. Well, we have you in Omaha. Okay, well, yeah, maybe I was in Omaha. 4 aces getting cigarettes. Story conforms. When asked about Trainer, there was nothing. And then, of course, he comes back to Cottonwood Apartments around 1 p.m. and he pulls into his normal parking spot. And we have a pretty lengthy video of the defendant dumping items into the dumpster and then just in his truck for several minutes. He's carrying a bag that's got an item in it, and it's a safe. And he's walking over to the dumpster, and he dumps it in the dumpster, and then he walks back with what? A bag. Got rid of it, came back to his truck. Officer Wright, he testified that he was the one that pursued the defendant on February 21st, when the defendant was with law enforcement. You saw the video of it, you saw the defendant. Eventually, the defendant was arrested on February 24th, but importantly, the truck. You got to see a video of the truck. And you got to see a vehicle that appeared to be running just fine. Didn't see any smoke coming out of it. In fact, the vehicle was running well enough that law enforcement didn't keep up with it. Come back to that. Sergeant James Doty. Sergeant James Doty testified that reported to be $1,200 in Eileen's black safe. He also interviewed the defendant, and the defendant admitted that there was between $600 and $700 in the safe. Sergeant Doty also followed up on the bank deposit. And 2 days after her disappearance, a $1,200 cash deposit went into his bank. You saw the video. You saw the evidence of it. There's a deposit slip for it. $215, $1,200. Defendant told law enforcement that he sold some tools on Facebook Marketplace. You already heard from Justin. He didn't sell any tools for his father on Facebook. He didn't sell any tools for his father and give him any money. Going back to the truck, Sergeant Doty also verified that the truck was in fact crushed. Lakeside Recycling. Interestingly enough, when the defendant was arrested on February 24th, law enforcement did a little walk around his truck just to see if there was anything damaged in the truck. The officer testified they didn't go get DNA, they didn't try to find any blood or anything. They were just looking to see if there was some kind of altercation in the truck. Appeared to be normal, they didn't do anything else with it. The defendant gets arrested, goes to jail, bonds out the next day, and what does he do? He goes and crushes his truck. A truck that appeared to be running fine in the video that you saw, and he crushed it for $750. Remember how I said use common sense? $750 he crushes his truck for. And wants to make sure the truck is crushed. Sergeant Doty also, as he arrived on the scene when law enforcement found the body, or when law enforcement came to the scene, the body was found on February 26th. Sergeant Doty was also the one that was able to verify that those are the clothes that this body appeared.
It's unfortunate, but not every lawyer is a great orator.
On February 13th, 2023. So, able to connect the missing persons case to the deceased body that was laying in a ditch 2 weeks later at 152nd and Old Mountain Bridge. Deputy Zach Norman, he was first on the scene, and he secured the scene. He's the one that called Sergeant Doty, and he testified as to his observations of the body, and his observation was there was some kind of ligature mark on her neck. CSI Hadley Kaba, she came out and took pictures of the deceased body. She also took pictures of the area, and this was in fact an area where a lot of people do dump their trash to a remote location. You heard testimony from Special Agent Nathan Houghton, who was the FBI individual that presented the CAST report. And there was a lot of information on that, a lot of technical information. But what we can distill from it is that both phones were together on February 13th. They were traveling together as well. And we would expect to see that in the morning, because we know from the evidence that the defendant is traveling. We know the defendant picks up Eileen and they're traveling together. And we know his direction at this point, so we expect to see the phones at that point. But what we also learn is that the phones are together and traveling together when they're not supposed to be together. Remember the evidence. The defendant says he dropped her off at Mike Brockman's. He goes to his apartment. At some point she texts him. Why are the phones together the entire time? Because he has her phone and they're traveling together, and this evidence shows that. Interestingly enough, both phones go off network at the same time when they go to Trainer. So her phone is with his phone when they go to Trainer, which is 14 miles away from Council Bluffs. And they're both, coincidentally, not able to communicate with the cell tower. Special Agent House said, well, all I do is deal with phone records. All I can say is that maybe they're roaming. Maybe it's airplane mode. Or maybe the phones are shut off manually. Detective Clark came in. He has different information. He doesn't have phone records, but he has the phone dump, the phone itself, the details from the phone. Because we got the phone information. And he did an extraction on that phone. And what we learned from his testimony is that when they're in trainer, his phone is manually shut off and manually turned back on at the exact same times that the CAS report showed them going off the network in the CAS report. So now we know the answer for the defendant's phone. We don't have Eileen's phone. We don't have Eileen's phone. We're able to get her records from the provider, but we don't have her phone. But we have the defendant's phone. So we know at least the defendant's phone was manually shut off during that period that he went into trainer and then came back through trainer.
That actually explains one of the questions that I've had, was what if the granddaughter had seen the photo, why were they
Dr.
not
Kelly
presenting it as
Cruz.
evidence?
What did we learn?
They don't actually have it.
Good techniques.
And, you know, I'm
Good
shocked
procedure.
his phone disconnected from
Good
the network at the
documentation.
exact moment that it was turned off. Go figure.
Good supplemental testing. It was a good autopsy. Dr. Cruz says the body just doesn't tell me enough. It doesn't tell me enough to support the conclusion of cause or manner of death. But she also testified that she's maybe only had 5 to 10 asphyxiation cases. Dr. Biden, on the other hand, he agrees with the mechanisms. They both agree on the mechanism. They both agree on the physical findings. But he believes the body tells a different story. He's done over 20,000 autopsies, and he's also done hundreds of asphyxiation cases. You have 2 opinions. There's actually 3 opinions, and it's the most important one. It's yours. Those 2 doctors, experts, don't have all the facts. You do. Count 1. We, the jury, find the defendant, Ivan Samuel Brammer, guilty of murder in the second degree. Asking you to find him guilty. Count 2. Asking you to find Ivan Samuel Brammer guilty of abuse of corpse. And count 3. Asking you to find the defendant guilty of theft, more than $1,500, but not more than $10,000.
Thank you, Mr. Ford. Mr. Mugg?
Do we want to take a break?
That's a good idea. Let's take a brief 15-minute break. That ammunition, open mind.
Even the camera guy's going, oh, thank God. That was funny.
Weapon. 25.
Okay. See, that guy may have rested, but don't forget, guys, we've still got the defense to sit through, and then...
This is now the opportunity for the defense to provide you their final argument. Mr. Munger? Counsel?
Dude, I'm the boomer that's supposed to be making it. Are you serious?
Thank you very much.
Come on.
Now,
There
I
it is.
told you on Monday that the state was going to try to paint you or write you a story. And I asked you to pay attention to the main elements of the story, the 5 W's as I call them. Who, what, where, why, and then how. The first thing that I wanted to start talking about was the jury instructions before I get into that. And each time we come back to my main slide, I have a snippet of the reasonable doubt instruction that you have, which is instruction number 16. That after a full and fair consideration of all the evidence in the case, or lack of evidence produced by the state, if you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty.
Now, Mr. Forney talks about some of the jury instructions, but I wanted to kind of highlight them from my end. So murder in the second degree, you've already read through these. Based upon the state's case, I do not believe that, one, this happened on February 13th, that two, Ms. Gowan died as a result of being assaulted by the defendant, and three, that the defendant acted with malice aforethought. And if the state failed to prove any one of these elements, just one, if they failed to prove it, then you must find Sam Brammer not guilty of murder in the second degree. Mr. Forney also touched upon malice, instruction number 23, and you all have that, and you'll have that with you back in the jury room. I wanted to highlight for you all that it is an act done out of hatred or with an evil purpose. And this has to occur while committing the alleged crime of murder in the second degree. This has to be an act done with so much hatred and such an evil intent that you must find Sam Brammer guilty of murder in the second degree. And ladies and gentlemen, they just don't have that. The second counts, instruction number 37, abuse of corpse. Again, the defendant says, or the state says, on or about February 15th, that the defendant either hid or buried a human corpse, or failed to disclose the known location of the human corpse, and that he did so with the intent to conceal a crime. I submit to you, again, the state has not proved beyond a reasonable doubt that the defendant has satisfied either one of these elements. And again, we'll talk about that a little bit more throughout my closing. Count number 3, instruction number 38, is theft in the second degree, is what he was initially charged with, but you have also the lesser included of theft. That the defendant took the property of another, and that he intended to permanently deprive him of that property. And again, I will submit to you throughout this closing that the state has not met their burden of proof to prove each element of this case, or each element of this count beyond a reasonable doubt. I had the snippet, which is the last paragraph of the reasonable doubt instruction on my home screen, but this is the full one, and again, you all have it. But I want you to remember what we talked about during jury selection. That a reasonable doubt is not all doubts, but it has to be of such a nature that you are firmly convinced that the state has proved their case beyond a reasonable doubt and the defendant is guilty of these counts. Remember we talked about the Tylenol example, how if you'd be a little bit hesitant, you would not give that Tylenol to your family. So when you are considering all the elements under all these charges, you must be convinced beyond a reasonable doubt. And if you are not firmly convinced and you hesitate, then you have a reasonable doubt. And I want you to consider that this morning and well into the afternoon of your deliberating. Mr. Forney showed you the verdict forms. The verdict forms I would like to highlight for you all are number 8, number 10, and number 12, which is finding Mr. Brammer not guilty on count 1, count 2, and count 3, respectively. So let's start with the first W. Who have we heard from this week? I listed some of the key witnesses. We have Mike Brockman, Detective Brannigan, Sergeant Boldra, Sergeant Doty, Special Agent Hout, Dr. Cruz, and Dr. Bott. I'd like to start with Mike Brockman. You all were allowed to take notes throughout this trial, and you are allowed to refer to them back in the jury room. I was also taking notes, so I'd like to highlight some of the things that Mr. Brockman talked about. When he is working, he nearly always traveled alone to pick up those parts as a part of his job. If he didn't bring back parts, it was rare, but it wasn't unheard of for his job to not bring back parts. If he went into Council Bluffs to go back into Omaha and did not get whatever part he was getting. We have timestamps.
All this is doing is
that you received
reinforcing
into
to me
evidence,
that
but we don't have any
he's
specific
sidelined
clock
back.
out times.
This is a
We just have
terrible
the hour that he started working
closing in my
and the
opinion.
hour that he ended working. We don't know what he did
He
that
had
day.
nothing to work with.
And Marcia Delavoy can't tell you exactly what he was doing back on the 13th, 14th, or 15th of February. She just can't tell you that, and neither can the state. The state made a lot of
Really? Once
argument
again, then you're
regarding
arguing
that
you.
the police talked to Mike Brockman that he had his story checked out. The police didn't do a lot of the same things that they did with Sam Brammer. They didn't send his phone for CAS analysis. They sent Sam Brammer's phone, they sent Eileen Gowan's phone, but they did not send Mike Brockman's phone. And I think that kind of gets to the heart of the investigation of this case. The police zeroed in on Sam Brammer nearly from the beginning. And they didn't do a lot of the things that they should have done in order to prove up their case, to show you beyond a reasonable doubt that the person they're accusing of a crime actually committed that crime. We also have some video of Mr. Brockman dropping off Ms. Gowan's belongings outside of Sugar's the evening of February 13th. He told her he could stay 2 days. She didn't show up at his house, so he just went and took her stuff and left it outside.
To be fair, that doesn't seem too normal to me.
Ms. Gowan's presumably only earthly possessions. She wasn't there, he didn't care. He wouldn't let them outside the back of the bar. But he hid it behind the cooler, ladies and gentlemen, so that was okay. They were safe behind that cooler. There's testimony, not only from Mike, but from Carol, that the house is always locked during the day. If Carol was out doing chores like she testified, then the house was locked. So there would have been no way for Eileen Gowan to actually go to that residence and pick up her belongings if the house was locked. That thought didn't cross Mike's mind, that thought didn't cross Carol's mind. So when she wasn't there, 2 days is up, I'm just going to go ahead and just drop her stuff off at the back of a bar. We heard a lot of testimony from Detective Brannigan, and I'm going to get into
That's like,
that
what am I, a storage shelter?
here in a little bit. We heard testimony from Sergeant Boldra. Sergeant Boldra was the officer that was wearing the body cam during the welfare check of Sam Brammer on February 19th. Ladies and gentlemen, Sergeant Boldra voiced concern over Sam Brammer, but if you remember towards the end of the video, they really just wanted to talk to Sam Brammer again. They talked to him on the 15th, they talked to him on the 17th, they had him again on the 19th, and he was told, you are going to be committed whether you like it or not. Now you can go freely with us and we'll give you a ride, or you're coming with us, but he was going to be committed that night. And if you notice at the end of the video, Sergeant Boldra was making sure that Sergeant Roberts was aware that, hey, we have Brammer again, if you want to go talk.
See, and that's the other thing. I mean, there was literally a point where the guy got sectioned. Mental illness and mental, degradation and all that sort of stuff was something they clearly could have brought up as a defense, or at least a mitigating factor. They didn't do that at all. I think he had to have told them. I really do.
Talk to him at the hospital. You also noticed in the video that while Sergeant Boldra was blocking up Mr. Brammer's truck before he took him to the hospital, that he had his flashlight, he was looking around inside, looking for a phone that Mr. Brammer was requesting. He testified he didn't see any blood. He didn't see anything out of the ordinary.
Well, to be fair, it's an
Remember what Dr. Cruz
asphyxiation
said
case. There's not going
during
to
her
be much blood.
testimony? The laceration on Eileen Gowan's scalp, the one that reached the outer table of her skull, didn't fracture her skull, but it left a little bit of a dent on her skull. While it was on her head, it would have produced a lot of blood. I asked her, are we talking about a liter of blood, like the amount that a person would donate if they're donating blood to the Red Cross? She didn't give us an exact amount, but she said a lot of blood. And Sergeant Boldra had the opportunity to be inside that vehicle on the 19th. He didn't know one thing that was suspicious or wrong, including any blood. Detective Fletcher
They're going to jump all
also
over
had the
bottom.
opportunity to look inside the defendant's truck a couple days later.
No, I don't
He
think
didn't
they
notice
can.
anything, such as blood or anything else in that
If he
truck.
tried to claim
He didn't notice
deficient
anything
counsel, basically what would happen is that they'd have
The
an
thing is, in
internal
this
hearing
case,
in front
they
of the
never
judge, and
asked
he would basically
Sam
say to
if
the
they could
judge,
actually go in
he
his
told
truck
me he was
to look
guilty.
around. He cooperated. He gave 4, 5, 6 interviews. He gave them his phone to do an extraction. He repeatedly said in interviews, check my phone. I don't remember where I was, but you can check my phone and you'll know where I was. Law enforcement did not look inside that vehicle.
Yeah, that's what I'm saying.
And
They're
whether
going to
it
jump
was
all
by
over that
consent
using Barden's
Or by
testimony.
some other method, if they wanted to, they surely could have. Sergeant Jim Doty. I made sure to take some notes, and again, these are just my notes. You're reluctant to rely on your own recollection as to what was testified during trial. Sergeant Doty spoke with Sam Brammer around May 3rd of 2023. This was 2.5 months after Eileen had went missing and 2 months after her body was discovered. Detective Doty
He can't. I
specifically
don't think he can
testified
actively say that he didn't do
that
it.
he had information that the safe
Because that would be
contained
misleading the
$1,200.
court.
You have in your jury instructions the statements from officers
Like, don't get me wrong, this
during
guy
an
is
interview with them
like,
are not
this is
considered
painful to
evidence.
watch, but I actually think
The only thing that
he's got
we know
nothing to work with. So
about that
I'm
safe
actually revising it, and I think he's
Is
probably doing a
Detective
better
Doty, or
job.
Sergeant Doty
giving
stating,
him-
I have information. He didn't tell us who, he didn't tell us
I shouldn't have
when,
been as
he didn't tell us where,
uncharitable
he didn't
as
tell
I
us
was
any of those
previously.
things. The last time the state showed you testimony or evidence that someone actually saw what was in the safe was from Nicole Skipper, Christmas 2022, a couple of months before this. Again, Sergeant Doty talked to Sam Brammer on the phone 2.5 months after Eileen Gowan went missing. And the fact that Mr. Brammer stated, my son stole some tools for me on Facebook Marketplace, we don't know what time frame he was talking about. We don't know if it was in March. We don't know if it was in April. We don't know if it was in May. You're allowed to determine the credibility of a witness.
He does kind of
Justin
look like a
Brammer
Nick,
and
doesn't he?
Nicole Skipper, the daughter and son of each of the individuals respectively, are in a relationship together. So you are allowed to weigh
Sounds
credibility
gay,
when
though.
determining these things, ladies and gentlemen. Special Agent Hope. He had a pretty well-rehearsed testimony. He's obviously given that testimony before. He'd like to enlighten you all that
just
they helped
on-
exonerate 6 people, in the United States
11.
in the 13 years that the program's been around. So he told you that he can only interpret the data that
But it's
he
okay.
receives.
It's a work from home
And
day.
the
or
data
something.
that he receives
I was tempted to take a mental health day
was
today.
from the historical cell site information
I'm just gonna take it
provided
easy and
by
work from
the
home.
service
I've got a
provider
few
and
things to do
case people. That's all I can do, and he didn't try to testify about anything else. And
Remember,
just as the
people,
state
always
said a
look
little
after
bit ago,
yourself,
the cell phones were traveling together
especially if it feels
in
like
accordance
it's
with the
just
video
fine.
evidence that morning. There's no doubt about that. You shouldn't have any problem with that. I don't have any problem with that. Mr. Brammer drops Eileen off in the area of Mike Brockman's residence around 11 a.m. on February 13th. Just because Eileen's cell phone may have been left behind in the truck, an old 1999 Ford pickup, does not mean that her or her deceased body was traveling in that truck. That is only the cell phone. And that is
Exactly.
the only evidence that you have.
It is completely circumstantial.
Now the state is probably going to bring it up, that if it was only her cell phone traveling with the truck, then how did she text Sam at 2:30, 3 o'clock that day? Again, this is an old truck. We don't know if it was locked. We don't know if you could just open the door. You don't know if Eileen didn't flag down a ride on Railroad Highway. You notice in the New Horizons auto video, there's about 5 or 6 cars that pass in that 2 or 3 minutes that you're watching. It's not an unbusy road. So the fact that the state's going to tell you, there's no way she could have got a ride. She didn't have her cell phone. She couldn't have contacted anyone. It's definitely not outside
Oh,
of the
good. I'm very
possibility that she
glad.
could flag down
Happy
a
to
ride.
have helped.
Got into Sam's truck and got her phone. The state has to prove their case beyond a reasonable doubt. And you know that there are more than one possibility that it could be involved with that cell phone. Dr. Kelly Cruz, I will talk about a little bit more, but you heard what she had to say. She is an unbiased witness from Iowa State Medical Examiner's Office. She is obviously
Unbiased?
a younger
That's really what
doctor.
you're going with?
She's still a doctor. She's still board certified, the same board certification that Dr. Bodden has. Dr. Bodden was glowing in his review of her autopsy. Dr. Bodden said that he has rarely seen reports as good as hers, that he had no issues with Dr. Cruz's technique, that she went above and beyond. He said that she had excellent autopsy and procedure. He loved everything that she did right up until the points where it really mattered. And that was his conclusion. And the reason that he gave his conclusion...
Yeah, sorry if you couldn't hear me. Yes, it's just gone 11 a.m. I've taken a working from home day so we could finish this trial off and a few other things. But what I specifically said, people, was remember to look after yourself. If things are getting on top of you, take a day, recuperate, do what you need to look after you, okay? Because you're at your best helping other people if you look after yourself first. But yeah, that's what I said.
Or said that second opinions or second reviews are better than the original autopsy is because that second reviewer or person who takes a second look at it has more information than the original performer. You heard Dr. Bodden testify.
I call that bullshit.
Yeah, police reports, same police reports Dr. Cruz had. He spoke to a member of Ms. Gowan's family, and he had her autopsy. Dr. Bodden didn't have anything more than Dr. Cruz had, and I submit to you, he had less than she had. So that brings us to Dr. Bodden. Obviously
Yeah, look, it does depend on whether or not
renowned
it's
and well-known
I do have the
pathologist.
distinct privilege of being my own boss.
Very good at testifying. He called Mr. Forney handsome, which I think all of us got a good laugh about. But all that aside, he was not here to take this case pro bono or for free. He was paid $8,500 a day, which he testified was a reasonable amount of money for someone like him. He was paid $17,000 to render this opinion. And do you think that Dr. Bodden would have been brought in if he had the same opinion or agreed with Dr. Cruz's
2 to 3
opinion?
days a week, that's pretty cool.
Going along with Dr. Cruz's opinion, Defense Exhibit 100, which is in evidence, is the quality assurance report form that was signed off on by Dr. Jonathan Thompson, the deputy medical examiner for the state of Iowa. He's been doing this, I believe she testified for 15 years. He reviewed everything that she did. You can look at the form yourself. Didn't find one thing wrong, didn't disagree with it. So when we're talking about second opinions and having someone else come in and review
Yeah, well,
it,
if you can do your job
it
from
wasn't
home.
just Dr. Cruz. She had her quality assurance
I mean, don't
reports
get me wrong,
signed off.
it does
It's
mean
not
you're
just
probably going to get
her
paid a little bit less now. At least that's what they're pushing.
conclusion that Dr.
But,
Bodden is calling the question. He's calling her question the report as well.
Yeah.
But we'll get into a little bit more about the pathologist later. Going along with some of the witnesses, and I think this is probably the best time to highlight some of the state's argument during their first portion. And that's something I'd also like to bring up, is this is the last time I'm going to be able to talk to you guys. After I sit down, Mr. Wilbur is going to have the opportunity to stand up and give you some more arguments. I don't get
I
another
don't think it's
chance
lag. I think it's
after Mr. Wilbur to come up and argue against the points that he makes. So when Mr. Wilbur is up here speaking to you all, I would really appreciate it if you could maybe think about how would the defense attorney respond to that? How would Mr. Munder respond to the point that Mr. Wilbur is making? Because I won't have the opportunity to get up here and tell you the points that I disagree with Mr. Wilbur. So I just wanted to point that out before getting into that. But responding to the state's arguments about some of the other witnesses, there were some inconsistencies. So we have Justin Brammer said that Nicole reported Eileen missing on 2:13 at 9 p.m. If you recall, Sergeant Roberts said he didn't get a report until 15. We had Megan Preston and the text messages that were received in the evidence. She didn't respond to the text message questioning the identity of the person during that text message. If you look at it, it says something to the effect of, very grown up, very responsible. But now that doesn't sound like Eileen. Not in the moment, not when she was actually communicating, but later. There's been a lot of
and
talk
that's the
of
thing.
this.
I think he would have been able to do a much
Diamond
better
stud hearing as
closing if he had something to work with, which again just tells me
It is
all I need to know about this
uncontroverted.
case.
There's no question that Mr. Brammer was arrested on February 24th for looting, and he had a $500 cash bond on each count for a total of $1,000. He was bonded out for $1,000. So what do you do when you owe someone some money? Not just someone, your granddaughter who bonded you out. You try to pay her back. That's what you can. He was broken up with Eileen. He told you, Emily told you it was the final time. They were not getting back together. So he had little.
The only way I would take that bet is if I could use it as a tax deduction, which we're not allowed to, so no.
Crushed his 1999 Ford pickup truck, which if you've ever been to an auto recycler, you don't get a haggle about the price of metal. The state's trying to tell you that this was just done in an opportunity to get rid of evidence. Evidence that they had the opportunity to look at multiple times. Sam was trying to pay back his granddaughter. He was trying to come up with that $1,000 any way he could. The state has also made comments during their arguments about
It's actually a good point.
insinuating
if
why would
if the
Sam
truck was going to be
drop off
substantial
Eileen
evidence, they should have impounded
at
it.
her alleged rapist's house. You saw the video again, actually 2 more times. Sam said, I don't know if she's telling the truth.
There you are.
According to Nicole Skipper, it was a very unhealthy relationship. He doesn't know if she's telling the truth. He doesn't know what's going on. So the fact that the state is trying to argue to you that it makes no sense that Mr. Brammer would drop off Eileen at a rapist's house who had just raped her the night before, he didn't know. He does not know whether that's true or not, and he states that perfectly clear on video. The state talked about Detective Dyer seeing Mr. Brammer rummaging around in that dumpster after he dropped him off after that interview. I don't recall Detective Dyer testifying to anything of the sort, but I want you to look back at your notes and see exactly what he testified to. Again, those are your notes and your recollection.
Darth Vader 1776, hello.
Speaking of the video that they brought up of Sam Brammer at his apartments, at the Cottonwood Apartments, the state makes a lot of argument that he's now taking the safe out of his truck in a black bag and tossing it in the dumpster. You know what you don't see in that video? You don't see Sam running to and from the dumpster looking like he's extremely frazzled, like he just did something extremely worrisome. He's moseying back and forth. There are kids walking by. Elementary school just got out. There are cars going in and out of the parking lot. Don't you think that if he was destroying evidence, as the state said, that he might be trying to vigorously clean his truck instead of just moseying to the back, dropping something off, going back in, not in any real hurry, doesn't have cleaning supplies, doesn't have anything else. So these are just some examples of the state's argument that they're just arguing to you. They have to prove their case beyond a reasonable doubt. And that's something that you need to, again, consider. And I don't want to keep writing this horse, but you need to consider and hold the state to their burden of proof. That they must prove every element beyond a reasonable doubt. Talking about the eluding in the state's argument, that we don't see any smoke coming from that truck. There's no way that engine was blown. They also stopped the pursuit. We don't know what happened 4 blocks later. We don't know what happened 2 blocks later. We don't know. And again, they're trying to make this out that Sam was running from the cops with a guilty conscience. He'd already been interviewed 3 or 4 times. He was stopped at a Walmart by the detectives. And they said, we want to talk to you. And he obviously didn't want to talk to them until a 4th or 5th time. So then they called the marked patrol car to light him up. I'm not saying that eluding is great or that he should have run from a marked patrol car. But he just didn't want to talk to the cops that day. Going to the what in this case. The investigation was led by Detective Rankin. He sat up here and testified for quite a long time. Now, again, in the jury instructions, you're allowed to consider the evidence direct or circumstantial, but you're also allowed to consider lack of evidence. And I just want to highlight a few things that I believe the state's lacking in their investigation. No camera footage from Omaha. We tried. It was deleted. We couldn't get it. They tried, and they couldn't get it. If they would have tried when this was a missing persons case, back when they knew 14 days earlier, they could have got it. This is something that they could have got. The fact that they're saying, oh, it was deleted, it's not our fault. No, they could have gotten it weeks earlier, and they chose not to investigate that avenue. No follow-up with witnesses who saw Eileen on February 14th. Again, Sergeant Boldra sat up there and testified. He said he took a report from Caleb Moore, and that report was that Caleb Moore saw Eileen at a food pantry on 34th and Broadway on February 14th. We heard no testimony from Detective Brannigan that he followed up on that lead. We heard nothing else. Dr. Cruz sat up here and told you when she spoke with law enforcement, there are multiple reports that Eileen was seen on February 14th. Just like with Caleb Moore, we heard nothing about these reports about who had seen her, where they had seen her. We know when they said they saw her, which was February 14th, the day after the state is alleging this event occurred. We have no DNA evidence. You remember the autopsy photos. There were the bags on Eileen Gowan's hands. Both pathologists told you those bags were to preserve evidence. Dr. Cruz told you, I did fingernail clippings, and I gave them to the proper law enforcement agency. We didn't hear anything else about any type of DNA testing that was or was not done. You heard both Dr. Cruz and Dr. Bodden state that strangulation, and not the neck compression that Dr. Bodden is talking about, but strangulation is a violent act, and it takes time. Dr. Cruz said it takes about 10 minutes. So when someone is strangling another person, that person is most likely going to be fighting, clawing, trying anything
Yeah,
to stop
it did sound like it said
themselves from being
that, Browning.
strangled. And you would think that during any of that fighting, that she would have the DNA or some type of evidence on her hands of the person that is actually attacking her. The state's going to try to tell you you can't claw someone when you're unconscious, but why would they take the fingernails and not run any tests just to make sure? Again, another lead that law enforcement did not follow up on this case. I've already touched on the blood, no blood being found in Bramer's vehicle. Also, there's no blood on Exhibit 9, the coat that Eileen was discovered in. The state apparently has some theory that she was lying back and the gravity caused the blood to go to the back of her head and not end up anywhere on her jacket or in the vehicle or anywhere else. If they're going to try to argue that this laceration occurred outside of the vehicle, she was in that vehicle. And according to them, she was unconscious and unmoving in that Burger King parking lot, during that Burger King drive-thru. There would have been blood on that seat in the Burger King drive-thru if this blow had knocked her unconscious. We also have the flock system that Detective Brannigan spoke about. Detective Brannigan and Detective Sergeant Roberts stated, we couldn't follow up on anything else because we were just relying solely on Sam Brammer's statements. We couldn't do anything else. You heard Detective Brannigan testify. I can put in a vehicle description. I can say, hey, it has aftermarket brush guards. It's got 0 taillights, as he said multiple times. And that system can find that vehicle traveling by any camera in the county. He said, oh, sometimes we get, hundreds, maybe thousands of hits. But they know the suspect's vehicle. They know exactly what to put in that system to try to track this down at an earlier point in time. And they didn't do that. Burger King. It appears to be the state's theory, but they're going to come up here and tell you we have the alternative theories. If you don't believe one theory, but you believe another, you guys can all agree upon it. But the state is trying to tell you that Eileen Gowan was unconscious, unmoving in the vehicle at the Burger King drive-thru. That Sam Brammer was breathing and heaving and just looking like he was about to pass out from exertion. You saw that video. You can see that video again. Look at the video. You can see Eileen's leg and maybe her arm. And the fact that her arm may be up on an armrest is an unnatural position. The fact that she's not moving is unnatural. She could have been asleep. But would it not have been nice to have heard from the Burger King employee who was in that video? He was kind of bopping around. He was having a good time at work. He wasn't screaming, oh my goodness, there's a dead lady in my drive-thru. Oh my goodness, there's a lady who just got the crap beat out of her in my drive-thru. She's bleeding from her head. She's got bruises all over her face. She's got a tooth knocked out. No.
I'm glad you're
You
able to
didn't hear any
finally
of that.
file the case. That's great for you.
I already talked about the fact that there's no historical cell phone analysis of Mike Brockman. And again, defensive wounds. There are going to be defensive wounds on a person that is strangling someone to death. A person, the state is going to try to tell you that she's passed out. They have no proof that she's passed out or unconscious. There are going to be marks on someone, probably their arms, when they are trying to choke someone, because that person's not just going to roll over. And
This guy's
you heard
basically using the
Brannigan
closings because it's
state
all he's
February
got.
17th.
He had
I didn't
openings
see
and he had
marks.
closings.
I didn't
He
see
couldn't really
anything
do anything in
with
terms in the
Brannigan.
middle because he couldn't present any evidence. Nothing in opening
those
or
are just some of the
closing
things
is
I wanted to
really
highlight that
objectionable because you're not
We're
providing
missing in the investigation.
evidence. It's
But
literally
it's
he's
not in the gospel
weaving a
list.
web and a story
And it's
to
not
try and
Mr. Brammer's burden to prove to you that
convince
he
the
did
jury,
not
and it's
commit
not-
the state's burden
I don't
to
think it's
prove
gonna
beyond
work.
reasonable doubt that he did. So, where did this alleged murder occur? We got Sugars, she's live at Sugars. We got Dudley Court, she's live at Dudley Court. Levi Carter Park, you all recall Special Agent Howe stating that they spent the two cell phones spent some time together at that park. And he specifically stated that was on the Nebraska side of Carter Lake. It wasn't on the Iowa side of Carter Lake. It was on the Nebraska side of Carter Lake. And that was directly before those two cell phones traveled to Burger King. They didn't take a circuitous route. You saw they went south and they went east. And it's of note that the arcs on Special Agent Haupt's reports does include some of Broadway where that Burger King is located. I believe he was testifying that it was at Brammer's residence, but those arcs, if you look at it, do include some of Broadway. We have the Brockman residence, and we have Trainer and Old Mormon Bridge Road. I don't know if you all recall, Detective Brannigan stated in that interview on 2/17, and let me pull up my notes so I can tell you what I have down. Detective Brannigan said, "You forget things, you know. I believe you that people do forget things. I understand if I were to ask,
Oh, don't
my
try and
co-counsel
use
Mr.
the
hey, what do you have for
detective's
lunch on
words
Tuesday?"
against him.
I would be
Don't do
willing to bet
that.
he does not remember. what he
Everyone
had
knows
for
that
lunch.
cops will say
It's not something
whatever they need to get you
that's
to be on their side.
misleading. When brought to his attention, Mr. Brammer
And the jury's not
gave
going to
them
give
more
a shit.
information. He repeatedly stated, "Oh no, there's no way that I went to Omaha." But he's saying, "Check my cell phone." He just didn't believe that he actually went to Omaha on Monday. He thought he might have went on Sunday. He did not believe that he went on Monday. But obviously, he did go on Monday. So when the state is trying to argue that he never talked about this trip to Trainer, how it's so relevant that he never talked about this trip to Trainer. Ivan, 62 years old, Sam, 62 years old, he obviously drives around a lot. You saw the historical analysis. He just drives around a lot. And the fact that he went out to Trainer and there's nothing of it should be of no value to you all. But again, you're the triers of facts, and you are to determine what weight to give evidence. Old Mormon Bridge Road. Old Mormon Bridge Road. You again remember Special Agent Haupt's historical cell phone analysis. Not one single time was Sam Brammer's or Eileen Gowan's cell phone anywhere near what they deemed the crime scene on that report. Not one single time. The state's gonna say, "Oh, then he must have left his cell phone behind." That's the only
Or he
explanation.
turned it off.
They had cell phone data from before the 13th until after Ms. Gowan's body was discovered. If at any time Sam Brammer would have made the trip up either to dump Eileen's body, or you know how they say that people go back to the scene of the crime a lot, to go back, see if anyone had maybe seen her body, the state would have told you that his phone was up there. It wasn't.
That's pretty weak, dude. That's pretty weak.
They cannot place Sam Brammer at the scene of the crime. They say, "Oh, he turned his cell phone off for 58 minutes on the 13th. Well, I want you to remember, it was on for 21 hours after that. It didn't go anywhere.
I don't know that that's helping you. I really don't.
Again, I talked a lot about the 14th, but I believe the state is just trying to make the argument that there's possibly maybe some testimony. I know Hattie Kava talked about the changing weather conditions and the fact that Eileen was discovered with snow on one of her legs or ice on one of her legs, that it had to have been on the 13th because it snowed late in the evening on the 13th, or 14th, 15th. We don't have any testimony that tells you exactly when it rained, when it snowed. This is all just people's recollections. They took down the reports. We don't know exactly. I think there's a little bit of testimony, but it was an unseasonably warm and cold February in 2023. Temperature was changing a lot. If there's a shadow covering the lower half of Ms. Gowan's body, I'm sure that there'll probably be some snow or ice left there, but we don't know. And they haven't, not only haven't they told us, they haven't proved to you that that was the case. The state is trying to argue that Sam Brammer killed Eileen Gowan because he was jealous, that he no longer had control over her, and she had to go. We heard testimony that, yeah, they had some verbal arguments. There was no testimony that there was ever any physical assaultive behavior. People argue, no one's perfect, but we don't have any history of assaulted. Sam Brammer was the one who asked Eileen to move out of his and Emily's apartment. It wasn't the other way around. If this was Eileen kicking Sam out of her apartment, I would argue, yeah, sure, he was mad as heck that he just was made homeless. But it's not the other way around, ladies and gentlemen. He asked her to leave. He said he was done with Eileen. So the fact that the state is now trying to argue there's a jealous motivation behind all this, it just does not add up. It does not add up that after they break up, the state's trying to argue he pawned this sentimental diamond stud earring. They were broken up. You heard Sergeant Roberts say at one point,
I keep telling
Mr.
you not to
Brammer,
admit to shit online.
things are getting more dire by the day. People who go missing, they're not heard from a little bit. It's not outside the realm of possibility that they're gone. And that can affect someone, whether they were done with the relationship or not. That can affect someone. Finally, I want to talk about how. And again, this relates
Thank
to
God you used the word finally.
Dr. Cruz and Dr. Bottom's testimonies, respectively. I'll start with Dr. Cruz. You have a report. You can go through her report as much as you want. You can rely on your notes. The main highlight is obviously manner of death. There are 5 manners. Or, I'm sorry, yes, there are 5. I apologize. Manner of death, how she was killed. She doesn't know. Cause of death. Homicide, suicide, natural, accident, unknown. Those are the 5 options she has. She could have chose homicide, but she believed there's enough evidence. She could have chose that someone killed Eileen Gown. She did. Dr. Thompson agreed with her as well. So when we talk about strangulation, we heard Dr. Bodden and the state talk about rear chokeholds, police chokeholds, and then all of a sudden, oh, we're not talking about chokeholds anymore. We're talking about the coats being grabbed somehow, and by grabbing that coat and putting it around someone, you're going to occlude, meaning completely shut off the blood flow from the carotid artery and the jugular vein on both sides of the neck at the same time without affecting the windpipe. By closing a coat around someone's neck. I don't know if you all have kids and you put on the puffy winter coats. Think about what type of force that would take to choke someone with a collar of a coat. There's going to be more evidence that a violent crime was occurring. You heard Dr. Cruz what she would expect to see in a case like this. Hemorrhaging of the soft tissue, bleeding of the soft tissue is what hemorrhaging is. She would expect to see broken cartilage, fractured larynx, fractured hyoid bone in the neck. She would expect to see petechia, which is the breaking of the blood vessels in the eyes, not only in the whites of the eyes, but in the other part of your eye. She would expect to see bleeding of the face. She listed off 15 to 20 things that she would expect to see, and she saw 0. Dr. Cruz told you she does not prefer to put undetermined as a cause of death on a certificate. It doesn't give closure. It doesn't do a lot of things that most people would prefer when you have a medical examiner examining the body. But she chose it, and she stuck by her opinion. She said that she read Dr. Ballin's report. She disagreed with it. You, as the state said, are allowed to bring in common sense and experience in this case. And not only are you allowed to do that, but the state has to prove to you beyond a reasonable doubt that this is what occurred. So taking your common sense and your everyday experience, wouldn't it make more sense for there to be evidence of injury when there's an actual strangulation, rather than some mysterious puffy coat preventing any type of injuries, but cutting off 2 arteries, one artery on each side, 1 vein on each side at the same time, without touching her windpipe, without breaking her larynx, without breaking her hyoid
Admittedly,
bone?
that does sound sus when you think about it.
You are allowed to bring in common sense. And 2 medical examiners, one medical examiner from the state of Iowa said she doesn't know. She does not have enough information to determine. And that was signed off on by her boss. So like I said, I will not have the opportunity to come back up here and speak to you after this is over. I really appreciate you taking time out of your busy lives, but this is a serious matter, and it deserves real consideration. And when you go back in that jury room and you start your deliberations, you have to be firmly convinced that Sam Brammer committed these crimes. Firmly convinced. Beyond a reasonable doubt. And I submit to you that you should fill out on each count that he is not guilty. Thank you.
Thank you, counsel. Ladies and gentlemen, I would like to move forward and see if we can complete all the argument. But if anyone needs a comfort break, I'll be happy to take a short 10-15-minute break. But I think we're all ready to move forward. A statement may be a rebuttal. Mr. Wilbur.
Hopefully this will be quick. I kind of feel like the prosecution's already made their point and the defense didn't make much in terms of a closing argument.
Counsel.
All right, I know it's been a pretty long week for you. This will be the last that you have to hear from the lawyers, then you get to do some talking. I want to start with sort of the who, what, when, where, why, and how. Since this is rebuttal, it's my chance to rebut their argument. I'm just directing you. That's not a combination of my school locker. That's the jury instructions that I think you need to take a look at. 21, 37, and 38. That's murder in the second degree, abuse of a corpse, theft in the second degree. These are the jury instructions. There's no 8th grade essay, who, what, when, where, why, and how. Like we spoke about this in jury selection. We have a checklist that we have to prove. It has the elements of the crimes. That's what we have to do. Now, obviously, it does involve somebody, right? Who? The defendant. Ivan Samuel Brennan.
I don't like that.
Right. What? The 3 charges. When? On or about February 13th. Where? Here in Iowa, at least some portion of it. That's the territorial jurisdiction instruction that you got. I'm not sure if I've got that listed. I feel like it might be 19. And I'm right, 19, right? If an offense is committed wholly or in part in Iowa, then we have jurisdiction. So that's the where, right? Why? We don't always get to know the why. We can certainly guess, right? But that's not something we have to prove. And we're not into guessing games here, right? How? Assaulted her, compressed her neck, hit her body, knew where she was, misdirected the police, took her stuff. I mean, that's the.
It's not even that it's aggressive. I feel like that was a little bit misleading.
Essays, we have to fill out anything along those lines. Follow the checklist. Follow the law. Another instruction I want you to take a look at is malice. When Mr. Munger was talking about it, he forgot sort of kind of an important couple of words there. He said you have to show actual hatred, evil. Then he moved on to talk about what evidence do you have of actual hatred or evil. Sort of missed the third portion of that instruction that says evil or an unlawful purpose. There's no suggestions here, there's no evidence here that Mr. Brammer hated Eileen Gow. Don't know there's a lot of evidence that there's a lot of care there, but we're certainly not, it's not the state's theory that there's hatred. The question is, was there an unlawful purpose with regard to what he did? 33 blunt force impact sites. And if you believe Dr. Bodden's testimony that she died from neck compression, it would have taken a minute to do that. That shows you malice aforethought. That shows you the unlawful purpose. There's no lawful purpose to twisting up someone's jacket while you're assaulting and beating the hell out of them. Right? There's no lawful purpose for that. So
Whoa,
malice is, if
objection.
you don't believe that we've proven cause of death, that's a whole separate discussion. But the malice is there. Mike Brock, possibly the worst
This
defense
is why
scapegoat
I
ever.
don't necessarily agree with
Completely-
prosecutors having the right of rebuttal.
You may, briefly.
The judge is over it, but he's also not happy with what just happened. Sidebar and scene.
Worst defense scapegoat ever. This is a gentleman that actually has a landlady that stays at his house, that has barking dogs. He has a boss that keeps timesheet codes. It'd have been a better call to say random homeless person than to say person that works 50 hours a week and has a timesheet that shows that. They in fact tried to make the argument that he could have been gone for up to an hour. She said that would be very unusual. right? His trips were 30 to 40 minutes. I mean, supposedly the theory is that it's reasonable for you to believe that Mike Brockman, somebody that allowed this lady, he's a good Samaritan, that allows not even a friend, really an acquaintance that he's seen a few times at the bar.
The first
He
guy was
allows her to
okay.
crash at
This
his
to me
place
feels
for a
like a
week.
prosecutor that would be
Defendant, of course, once
happy
she's moved in with
bend
him,
certain
one day
rules
after
in
they
order to
broke
get
up, right
a
now, we've got somebody else involved.
conviction.
Right, this is just a gentleman that is just trying to be a good Samaritan and give her a place to stay. But you can see, I mean, it sort of sounded like Sam Elliott, you know, what's for dinner, right? He's just super cowboy, low voice, straight shooter. That was the deal. She got to stay with me for 2 days. 2 days was up. She had to get her stuff. She didn't show up. I left her a message. She brought her stuff back. I mean, that's pretty much exactly
with
the way it
friggin-
was.
Are you kidding
I
me
mean,
with
pick
this?
somebody that doesn't have like almost airtight alibi during this entire period of time. If you 12 people believe that it is reasonable that Mike Brockman is responsible for this on the 13th of February, I will submit to you that you're going to have a very early day. You're going to go back, you're going to let the foreperson, and you're going to let him, you're going to find him not guilty on
That's
all 3
stupid.
counts in about 5
I don't
minutes.
like that.
If you think that that is reasonable, that's that you have a pretty simple job for the rest of the day. But I feel like I got a little righteous indignation, a bit, right? I mean, who should the police be looking at? Seen on video, picking her up at 8:30. Gives a false story about what happened. Seen on video, she's walking down the hallway, perfectly fine, with a black safe that they know has $1,200 in it. Coincidentally, a couple days later, he pops $1,200 cash into his bank account. Safe never shows up again, right? She ends up dead in the same clothes as well. I mean, who else of the 8 billion people on the earth should they be looking at? Obviously, we have to make sure we've eliminated everyone. But it's not a shock that that's the direction. He's given false statements. He's misdirected the police. He's been responsible for destruction of evidence. State's theory. I will admit, the lack of blood on the coat is a little weird. Not going to pretend like that's not. But somebody bumped her on the head really hard, lacerating her scalp and taking a divot out of the top level of her skull. That absolutely happened. So whether it was the defendant or the mystery man, you're in the same boat. You're still stuck in the same boat. There would still be no blood on that coat. That is an issue that helps him. It does make it an interesting mystery for everyone to solve. So does the state have a theory? Certainly. I mean, if invited, state's theory is that there was some sort of assault, that her coat was twisted up, that she's down. It's pretty easy. You got somebody down, you're twisting up their coat, and you're beating the hell out of them with something. 33 times. And during that, was there intent to compress that neck and kill? Maybe this is just an assault gone really bad. You've got an instruction that says murder in the second degree does not require specific intent to kill. This isn't a murder in the first degree. This isn't a premeditated, meant to kill case. Right? Perhaps it's just a really, really brutal assault that ended up with a tragic end to her life. But that's still murder in the second degree. Bob and Cruz. So I want to talk about them a little bit. Obviously, I've got the 15 in parentheses, that's for my note. That's for you to pay attention to instruction 15, which is the one that talks about expert witnesses. So you're supposed to pay attention to the training, their experience, and then decide, what you believe. The reality is, on the vast, vast majority of cases, Dr. Bodden and Dr. Cruz are of one mind. I mean, nobody's disputing how much the heart weighs or how much fatty tissue is in the liver. Nobody's having any disputes about any of this stuff. The contusions are where they are. They show what they show, right? The difference is in the interpretation of those findings. Dr. Cruz is
She was on the side of a road. She could have easily been hit by a car and someone could have left her in the ditch.
Fantastic forensic pathologist.
Who's to say she
But
didn't
she's
get out
been
of the
doing
car?
this for 5 years. And she said she'd seen 5 to 10 asphyxiation homicides in her career. Dr. Cruz's relationship with death is still developing. Dr. Bodden has had a pretty close relationship with death for over 50 years. He's completed 20,000 autopsies, including handling hundreds of asphyxiation homicide cases. You can see his resume, his CV, Exhibit 14C. Please read that. Please read the first page. The types of cases he's been called into. And this is not talking like, hey, back when I'm not even born, he's out doing things, which he was, right? This is him being brought in by Congress to do the assassination select committee for the deaths of President Kennedy and Martin Luther King. This is him being brought in the 2000s to Poland to help them investigate the death of their president. This is him being brought in with Kobe Bryant's death here, fairly recently. This is him being brought in the very high-profile George Floyd case that America had to deal with about 3 years ago. I mean, he has been in the center. He is one of the world's most renowned forensic pathologists. And a family's quest for justice, they were not going to accept that one person could, with one opinion, say that their mom, that their sister, that their daughter got no chance to have her case heard in court. And so they went out and they found one of the world's best. And Mr. Munger is 100% correct. If Dr. Biden would come back with an opinion,
that doesn't mean he doesn't necessarily get it
I
wrong.
agree with Dr.
It doesn't mean you're
Cruz.
infallible. It doesn't mean you're not human.
We might all still be sitting here today, but we wouldn't have a count one, right? We wouldn't be dealing with a murder of the second degree, because if you've got no cause of death, that's sort of a tough case. Dr. Baden has the experience. He has seen these cases, and she didn't just die for no apparent reason. I mean, I'm not sure if the defense is, we don't know, she just coincidentally died right after this brutal assault, just happened to die. He has given you the mechanism, and there's physical evidence to support it. We've got the abrasion on the neck that looks just like a zipper, and even Dr. Cruz says looks just like a zipper. That's why she's getting into the neck, looking at all those internal structures. But she's thinking strangulation, just like the defense wants to try that case. They're like, this isn't a very good strangulation case, I'd like to defend that case, right? So that's why they keep talking about manual strangulation. But this is not a strangulation case. Dr. Cruz said it wasn't a strangulation case. Dr. Baden says it's not a strangulation case. Matt Wilbur, Potawatomi County Attorney, is telling you this is not a strangulation case. You know what else we have crap evidence for? A gunshot death. We also have almost no evidence of a stabbing death.
Disingenuous.
Right? We have none of those. Why? Because that's not this case. She died because she got brutally assaulted, and the vessels in her neck got occluded enough that it took her life. The Exhibit 100, I just want to talk about one exhibit that the defense put in.
He's just talking that first.
Okay. It's the quality assurance document. Well, you should take a look at that, because it's not like, it is literally like, was the subject adequately documented? Yes, it was. Were there enough pictures taken? Yes, there were. Was there adequate descriptions in the report? Yes, there were.
He still didn't look at the actual body.
Agrees that it says, was the opinion consistent
I'm going to
with the
value his
findings?
opinion less
literally,
because of
go
that.
through all of that. I would bet had that document been reviewed line by line with Dr. Baden, he would have agreed with pretty much every line that was on it. She did do a fantastic job. She had accurate documentation, she had great photography, she had great technique. It's a question of, if you don't have the information in your brain that you can access, then you can't give that opinion. And if she's had 5 to 10 asphyxiation homicides in her 5-year career so far, she talked to you about all the different methods of asphyxiation, the most common being strangulation, right? So if you're thinking strangulation, then that's what she's looking for. You got strangulation, you've got smothering, you've got drowning, you've got all these things. She said there's chemical asphyxiation again. There's all these sorts of asphyxiations. How many neck compression deaths has she handled in her career? Well, I submit to you less than 5 to 10 that are the total. As Mr. Forney said in his opening argument, right? Honestly, it's your opinion that counts. We have presented you with the evidence. You weigh it, you make the decision. This is not a place where one person or one doctor gets to say what happens with a case. We live in a system where
Really, because I'm pretty sure that's what you're trying to
this
push
isn't
on.
Matt Wilbur saying, do this, you get to make that decision. There are some unanswered questions in this case. Absolutely would like to have different things. Would like to have had somebody be able to examine Eileen's right eye. That would have been nice. Would have been nice to have the truck formally searched.
Well, why
are
wasn't
there
it
mechanisms to
formally
do that? You said by consent or otherwise. The otherwise, that's what we call in our line of work a search warrant. Sure,
No,
but they require all something
that's
else. It's
legitimately
called,
how fast he's
probable
talking.
cause.
We're at
You have to know
1.25.
a crime has been committed. And are they getting suspicious by later in February? You are right. They are getting suspicious. But the body isn't found until the 26th, and he is crushing the truck on the 25th. Yeah, DOT evidence, the video, they said they only kept it so long and then it gets overwritten. Again, that's a problem. I wish we had that extra video. Why does the state not? Because somebody is playing misdirection, right? Somebody's playing the shell game, getting the police to run around chasing their tail, trying to run down all his various false statements. And so they get to look in here, and it takes days before they figure out that he's actually even gone into Omaha. Sergeant Doty. When Mr. Munger said that the statements of officers aren't evidence, that's when they're interviewing the defendant. So I just want to make that clear. That was a little bit of a tricky statement. When Sergeant Doty is testifying on the stand, And he said, we received evidence that there was $1,200 in that safe. And there's no objections, that's his testimony. What he says on the stand is evidence. When you're watching a video interview of the defendant, that's a different thing, right? Words that the defendant says are evidence, not questions and statements of law enforcement during that interview. During his interview with with Sergeant Doty, this defendant said he knew that there was $600 to $700 in that safe. The other evidence that the law enforcement had received was that there were $1,200. He doesn't know how much is in there. He just knows there's at least $600 to $700. What a coincidence that the information that law enforcement received, that there was $1,200, just happened to match up exactly with the amount that he's depositing 2 days after she's gone missing. While he's not working. Hasn't shown up for work. Right? Megan Preston testified, that she never saw him again after that physically. Remember, because she watches him hanging out in the back and the parking lot at some point in a vehicle. But she sends him a message like, hey, if you're just sitting out there, why don't you come on in? Never shows up. She hadn't seen him since the 13th. She had not seen him again until she saw him in court this week. Never showed up to work. But he's flush with cash. And remember, this is before the crushing of the truck. The perfectly functional. Nobody's suggesting that you should go haggle with the recycling dude for $775 versus $750. The point is, we have a legit running F-150 with some extra aftermarket stuff that's clearly worth more than $750, and he's crushing it for $750. Why do you do that? If you are in such a position that you don't have hardly any money in your life, why are you going to purposely get rid of a truck?
Because
for
he
way
felt
less
that
than
he
the market
owed his
value?
daughter
And the reason
money,
is, and
his
he sticks
granddaughter
around
money,
and he wants us
dickhead.
to make sure it's crap. Why don't you just walk in? If it's such a crap truck, why don't you just walk in and say, hey, give me my $750 and walk out? And he stuck around and waited to make sure he saw that truck actually get crushed. Because the value of that truck to him at that point was its value as potential evidence. And he wanted to make sure that that went bye-bye.
I don't like this. I do not like this.
Cross-examination. You have instruction 41, one of the last instructions that you have. And it talks about why you should not be looking at things like Google and YouTube and all that other stuff, right? Because it says that that is stuff that comes in outside the trial process. And part of that says that we don't want you to do that, and don't do that, right? Because you can be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth, and by cross-examination. Cross-examination is the method that we use in the American justice system to test for truth. It is not. It's supposed to give you the best evidence you can. Even Dr. Bodness, he's getting in the hot seat with Mr. Reedy, right? And he's like, I'm sure you probably don't like my aggressive crossing. I expect it. That's the system, right? That's your job. You're supposed to be very aggressive with me because that's how you, the jury, get to know the truth, right? What it's not supposed to be is a gotcha tool, right? Like this. You don't even know what the standard is for a reasonable degree of medical certainty in Iowa, do you, doctor? Because that's a trick question because there is none. Because you heard Dr. Cruz. I'm certainly arguing.
Excuse me. The objection is overruled. The jury is again instructed to rely on your own recollection as to what was stated. And at this point, counsel...
Oh, I know, Your Honor. I personally would have called a different
what Dr.
objection,
Cruz
eh?
said. That he asked her, what is the standard for reasonable degree of medical certainty? And you know what her quote was? It's person dependent. It really is based on my training and experience. There is no number, right? So that's a gotcha. Yeah, that's a question that had no possible answer for him to answer correctly. He's like, I don't know what the standard is. Like, well, there's a good reason you wouldn't die, because there's none. It's person dependent. He told you what his standard was. He wants to be 95 to 99% sure on his opinion. Right? You never got that number
He's
out
about
of
to blow
Dr.
his
Cruz. She
steam
just
from the
said,
sounds of it.
it's whatever I feel comfortable with. But her specific exact quote was, it is person dependent. That's what I'm talking about with gotcha cross. Right? That didn't help you as a jury try to decide actually relevant information about helping you test.
He shouldn't have been mocking
the
the
other
other
big sort of gotcha
attorney, though.
cross is
That was
missing in
inappropriate,
this case.
in my opinion.
Right? We're hearing about this.
And that's
this,
really the objection
theory
that
of
was
like,
brought up.
why didn't they run down these 3 tips? Right? What happened to these other 3 people? Why did they not ask Ted Roberts that, who was in charge of the missing person? Right? They ask Ty Boldra about what happened. He's like, I don't know, I just get the tip and it gets passed up the chain. They ask Dr. Cruz, had you heard about this? Whatever happened with this? I don't know. But nobody knows. The person that knew that was actually the person running the missing persons investigation. They didn't want to ask him that question because he had answers for it. Right? What you've heard about this, there was no DNA testing done. You don't know that. What you know is that there's no DNA tests that are in evidence in this case. Because nobody asked the question of Detective Brannigan what was done. Right? It was wait and then play gotcha. That's not helpful to you. This is a big case, folks. You need to be, I understand there's a job to do. There's a client that...
You may.
There we go. Dude needed to chill the F out. He was crossing certain ethical boundary lines there that I was not appreciating. And hopefully the defense is actually going to have a half-decent win here. Which might be the only win that they get in this case. But he shouldn't be attacking them personally like that. No, it's on 1.25. Would you like me to slow it down? I'm happy to. He's just reclining in his chair because he knows he's going to jail. Prosecutor crossing the line. I'm shocked, I tell you. Shocked. Oh, that was a bit dirty. That was actually starting to get me a little bit under the collar there. Is he in PJs? No, I think he's just really that bad of a dresser.
The defense obviously has no burden to put any evidence on. But when they make an argument, they are subject to the same credibility determinations as anything that the state says. They don't have to put on any evidence. They don't have to ask a question. They don't have to do that for any particular witness. But when they stand up here and ask the question of why you don't have that evidence, when they have chosen to go a different route,
Don't you comment on their
it's for you
tactics.
to learn the truth in this case. Okay. Paying Emily back. Speaking of which, however, what evidence came into this case that there was some concern about paying Emily back? None. I mean, maybe there was. I mean, maybe she said, I'm bailing Grandpa out of jail and I expect I'm going to get paid back. But again, you have to deal with evidence that actually came in this case. Nobody testified. Emily never said anything about that she expected that she was getting paid back, or I was pressing Grandpa, I'm like, you know, I really could use that $500 or $1,000 or however much it was. Right? You have no evidence of that.
No one said that she didn't either.
Dyer in the dumpster. Specifically brought up my folder on this because he said, you check your notes, and I hope you do check your notes. When Detective Dyer testified, was specifically asked, right? Said I dropped him off, he went to the dumpster on the southeast corner of the apartment complex, looked in, and he looked in, then walked
Maybe he
away.
was curious to see for
Not
himself what was
rummaged
allegedly
around.
there.
Hey, I suggest none of you have notes that he rummaged around because that testimony didn't happen. Right? But he absolutely showed up on the 15th, and Dyer testified to that. This time was different. Right? That's what the suggestion for the state is why this tumultuous up and down relationship, this rocky road, this on and off again situation, this time was different. As Emily said, he said, as Emily told us,
Hey,
that
Tim
told
Pater.
her, this time it's final. That's why this whole situation, why he spun up about it. Pattern of life is something that we
What
look
color
at
is
trying
the
to find
folder?
win.
Off
When
what?
does
Beige.
someone, when do we know someone is really no longer on the earth? Well, I mean, obviously when you find her dead body on the 26th, pretty good. But her pattern of life ended on the 13th. The last time anyone spoke to her, heard her voice, on the phone or in person, was on the 13th. You have no evidence that anyone on this entire planet ever heard her speak again after mid to late morning on the 13th. We have a text message that was sent. I would submit to you, while it's riding shotgun with the defendant, right? Submit to you is more reasonable. He's the one that's sending that, that text
Counsel.
message. But certainly, nobody heard her voice. Her daughter, you got a lot of family members here, right? Her daughter talked to her mom every day. Nothing. The CASA agent said there were over 200 contacts early on between these two. After this date, after 13, 2. And again, those are texts going out. There's no conversations, 2. Because he has no need to communicate with her because he knows she's dead. So we call pattern of life, pattern of absence of life. You don't have a single bank transaction, human interaction, nothing. Because her life has ceased to exist. This is just too coincidental also to be a coincidence.
Yeah, all very
I'll put this up on the
circumstantial
big
though.
screen. This is Exhibit 8A. Right, this is the autopsy. And I say this is too coincidental to be a coincidence. Because isn't it coincidental that we have a zipper mark right next to, what's that thing right there? Oh, it looks like a zipper. Right? That's what we're dealing with right there. Right? A zipper right next to the injury on her body that sure looks like, and you'll get this, you'll get a chance to go back. You obviously have seen a lot more zoomed in ones. But this one's got the coat and the zipper right next to each other. What a coincidence. I mean, it's not like a really weird comparison to hold up that jacket, take a look at it, take a look at what's on her neck and say, looks pretty coincidental. Just sort of one of the final things about the phones, because Mr. Bunker is correct. We don't have any evidence that, other than her dead body in the same clothes that she was found in when she was with him, we don't have any evidence of him traveling to that location, because phones don't transmit when they're off. And we've already learned that he knows how to do that. Right? Hours at a time, those are off. This is not a location that is miles and miles away. This is Crescent, Iowa. This is just halfway between the interstate and Crescent. This is a 10-15 minute drive. Phone off, zip up, dump a body, come back, phone on, back at my apartment. It's all the time it takes, half hour. I don't think the defense is that he did it somewhere else, but that still seems to be the cast stuff showed that he was over in Nebraska. I just bring up again to you, take a look at instruction 19, which is territorial jurisdiction, that if a body is found, the murder of a murder victim is found in
Thing's going
Iowa,
on me is
then the
he's
death
gonna be
is
found guilty
presumed to have
despite
occurred
this
in
bullshit.
Iowa. That avoids the state line tap dance, right? It's a presumption. You're not required to believe that that's what happened, but that is what we call a legal presumption. So the fact that she was found here, that's enough. Again, this is not a strangulation case. Dr. Cruz was looking for that, and she did a good job looking for it, and she did a good job of eliminating that. Dr. Bodden does not disagree. This is not a strangulation case.
Yeah, he's very sold.
I'm just getting very close to being done here. I want to sort of give an apology of sorts. I apologize for the tech problems that we had on day one. It's a struggle when you've got county computers and state court systems, and you're trying to get them all to talk to each other. You can't really control what a witness says on the stand, but you ought to be able to control your computer. And I apologize for that, because I don't like to see that happen. I apologize because I'm sure this was really boring. I mean, honestly, right, you expect, I mean, closing arguments are, can be exciting. And listening, I think, to witnesses like Dr. Cruz and Dr. Bodden that are obviously, very articulate and do a good job explaining complex information. But this is not like TV. You got to sit through days of pretty drudgery work, and I apologize that you had to do that. Sorry, lose my voice.
Good, then shut the
I don't apologize for putting in the evidence that we did, because we're going to give you the good, the bad, and the ugly. That's our job. This is a case where the defendant took three things. He took her life, he took her property, and then by dumping her in a ditch with some trash, he took her dignity. This is the time for justice. Mr. Bramer is presumed innocent and not guilty until the evidence establishes guilt beyond a reasonable doubt. This trial is over, the evidence is in. I would submit to you that we have overcome this presumption of innocence. Eileen was a mom, she's a grandma, a daughter, a sister. And she tragically lost her life. I'm asking you for a verdict of form of verdict number 1. Hold one out. Form of verdict number 9. Hold one count. Form of verdict 11. Hold one count.
Thank you, counsel. Ladies and gentlemen, you've now heard arguments from both the attorneys. The case is being tried, is concluded, and the matter is now submitted to you to begin deliberation. There's 2 things I need to do before I send you back to the jury room. The first is I need to have Ms. Gal and Ms. Smith come forward. These 2 ladies will be serving as the court attendants that will be with you. We'll direct outside here. If I get both ladies here, do you swear or affirm that you will take and keep this jury together in their jury room and not allow any person to speak to or communicate with them, except to ask whether they have agreed upon their verdict, and not to communicate with them the state of their deliberations or the verdict agreed upon until after the same shall have been declared and received by the court, or they be discharged by the court, and that the exhibits taken by you and delivered to the jury shall not be left unattended or tampered with until returned into open court. If so, say I will.
I will.
Thank you, ladies. The other item is you were called back on Monday, which seems quite a long time ago, during jury selection.
Can we come out to stand and talk about releasing the alternate, right?
Yes.
Can we have a moment with that first before we do that?
Very brief one, right where you are.
He's not going to try and say if he was in his own defense now, is he? Surely not. Audio, give us audio. Come on, audio guy. You got one job in this. Prosecutor's already blaming the IT. You might as well.
And my purpose is just to make sure that I've got 12 people that are able to stay with me through the entire duration of the trial. Sometimes you have someone become ill, or maybe a family member becomes ill, or there's some family emergency, and they're asked to be relieved. And if the court has an alternate, I'm in a much better position to grant that request. Fortunately, all of the 13 of you have remained healthy, and there's been no other family emergency. And I'm, again, fortunate that all of you could say and deliberate. But the law tells me it's a jury of 12 people. And so I'm going to announce and then release the alternate now. And I want this individual to know that before she leaves today, she needs to provide her cell number to Ms. McDowell or Ms. Smith, and I will personally call the individual when a verdict is returned and let them know what the verdict was. Our alternate is Michelle Mabbitt. So, Ms. Mabbitt, I thank you so much for spending the week in hearing this case. Again, as I stated on Monday,
I got to say, being the alternate really
think
would
jury
suck,
service
having
is
to sit
perhaps
through
the
the
best,
entire trial.
example
And
of
then
the
you're
rule
like,
of
"Oh,
law
man,
at work in our
never
society
gonna
that
home.
only works when people like
Screw
you
that."
spend a week out of your daily lives. And so again, on behalf of the court, thank you for your service. And don't forget to provide Claire or Olivia a number, and I'll call you. All right?
Just dox the court
And with
staff
that,
while you're at it.
Ms. McDowell, Ms. Smith, jury is in
Love
your
it.
hands. Have them back to the jury room.
Look, I kind of feel like he could have just said juror number 2 or 7 or whatever else. But there we go, people. That's the end of the trial. Give me 2 seconds. I'm just finishing something up, and then I will move us ahead through deliberations, because basically we know what the outcome of this was. So, oh, hang
I
on.
want to make
Back
sure
on the
that
camera.
Tish has an opportunity to gather the evidence and get it to the jury. And my thought is that it may, time-wise, be more efficient if I have you just back in chambers in 15 minutes to make some record. But I'm going to make some record on the most recent sidebars. If you'd rather do it right now, I'm fine with that too. All right? Well, let's take care of it.
I agree. Let's take care of it.
We're doing some housekeeping. I'll give you a few minutes to do that, and then I'll take care of it. The doors. And I wanted them to know that they're free to leave. As I began, I looked up, and half the gallery was standing and moving toward the exit doors. And I wanted them to know that they're free to leave. This is a public hearing, public trial, and so anyone that wishes to stay, they're free to stay, and some folks have remained. The court, again, wishes to make record on a number of objections during the rebuttal argument of Mr. Wilbur. There were 2, and I'm going to take them separately.
Okay.
The first was in an argument by the state's attorney that the jury had heard
I'm curious how he's going to handle this. So he's pissed off about the objections.
Plaintiff's attorney referenced Mike Brockman as, quote, worst scapegoat ever, end quote, and then was arguing in an effort to rebut the defendant's suggested theory, as I understood it. The objection at the sidebar was overruled.
However,
Based on the fact that we do have evidence from the defendant's own statements during the trial referencing Mr. Brockman, and the court allowed the rebuttal argument. That's the court's summary of the sidebar. I'll allow both counsel an opportunity to make any recollection, or excuse me, any additions or corrections of the court summary or any other record they'd like to make?
That was a
Mr.
4
Wilbur?
against
I think your summary is accurate, Your Honor.
Mr. Munger?
Judge, my objection was based upon Mr. Wilbur about to get into arguing about or opining about the credibility of a witness, which is in direct violation of this court's motion to eliminate, about giving an opinion as to the credibility. It's within the purview of the jury only, so that was the reason for my objection. Otherwise, the court summarized the sidebar appropriately.
Great. And then I also would add then, after my direction to Mr. Wilbur, that he could continue but to move on from that and not be finding about credibility. He did.
I don't believe I opined about Mr. Brockman's credibility or anybody else's. It was the
No, I think
the
Mr.
credibility of the argument having to do with
I
Mr.
think Mr.
Brockman.
Munger's reason of approaching the bench was he wanted to nip it in the bud before you got there.
And also calling him a straight shooter. I don't know what other connotation a straight shooter has other than, hey, you got to believe him.
All right. Any other record by either counsel on that?
No, Your Honor.
The second sidebar, again, was during rebuttal argument. And this was argument made by the state's attorney, Mr. Wilbur, concerning or revolved around defendant's cross-examination and his reference to instruction that cross-examination, as well as the entire trial process, are tools to reach the truth. Mr. Wilbur's reference was concerning questions of, I believe it was Sergeant Baldra, concerning tips that had been received by the police department, and the prosecutor's statement that that was not something that Mr. Baldra was aware of and could not respond further, but that was something that could very well have been asked Sergeant Roberts, who was leading the investigation of the missing person.
Yeah, that
And
was
it referred to as got you cross-examination. There was a separate reference a few moments later concerning a similar type of argument revolving around Detective Brannigan and DNA evidence. The court's concern
Get your notes in order, Your Honor.
along with a number of matters, was burden switching, and the court made clear to the state's attorney that he needed to make a statement that confirmed that the state has the only burden in this case, and the defendant has none. That's the court's summary of the sidebar. I'll allow the state's attorney and the defense to make any further record. Beginning with Mr. Wilbur, is that a fair and accurate summary of the sidebar?
I think it's accurate, although I think there was one other, just to be fair, issue that Mr. Reedy was taking. That's when I said he was playing gotcha cross-examination with regard to there being a lack of a standard for reasonable degree of medical certainty, which Dr. Cruz had opined, or had given the answer that it's actually person-dependent. So he was upset about 3 different statements of gotcha cross, but your summary of the sidebar is accurate. Do you want me to make further record now?
Any record you have?
No, I would just say I believe that I was making fair comment on defense argument, and any commentary I made was invited by the defense. That's my position.
Either defense counsel can respond.
Judge, my position is that he has no right to say we had a duty to ask anything. What
No,
we choose to ask is our
absolutely
right.
not.
He cannot then say, but we should have asked. We should have done. We
He didn't
could
have to do
done.
anything.
Any of those things are improper burden shifting to us. He does not have that right to say, we should have asked about the DNA. We should have asked about the fingernails. We should have done anything. Any one of those is improper. And it's not good enough for him to get to make the comments and then come and say, what's our burden? He's already made the comments. He's made it to the jury of
He
saying,
already
what the hell? Why didn't they do
Just
something?
about that.
He's already done that. That's the improper part, Judge. That's where he overstepped the bounds.
And the court's final comment is that I overruled the objection, but did state to all counsel that I believed that the state's attorney was getting dangerously close to a burden switching, which was the argument from the defense counsel. I then directed the prosecutor to make clear in his argument that the state has the burden of proof. And as this jury has heard from me on at least 2 occasions, if not more, and are included in my instruction, that the state has the burden to prove everything in this case. And for all
I'm
those
not sure
reasons,
that's sufficient,
the
Your Honor, I'll be perfectly
objection,
honest. I'd be making a stronger
both
argument on
sidebars
that.
were overruled. Any other record needs to be made at this point?
Maybe just, I'm just thinking housekeeping, Your Honor. I don't know if we have to do this on the record, but what's going back to the jury? How are we going to handle that? I know we had some brief discussions yesterday. My understanding is everything's going back except for the videos, but then we have to figure out a way if they request to watch those, how we're going to get that done. Is that your understanding, that we're going to keep the videos, or are we going to just send it all back and just don't give them a player unless they ask? I don't know if we ever clarified that.
I do have a blank laptop back there. I know previously I had to keep plugging the flash drive to it. So there's nothing on that computer. So
I don't think we have any evidence that's on a flash drive, though, do we?
We could, I mean, we certainly have everything that's in a video we have on the laptop. So there's no question that we could take, I mean, it wouldn't even take that long. I mean, we could do that for a flash drive. Option 2 is figure out an external DVD. Jen, do we have an external DVD in the office at all? Yeah, so I mean, we could give them an external, DVD player, and then they can just play the discs themselves. I think that's cleaner.
Option for 2.
I agree.
I do too.
I agree.
If we have that external disk drive, then maybe the cleanest thing to do is provide them with everything now.
Perfect.
Claire, from what you're telling me, you did find a blank or a stripped down laptop. There's nothing on it.
correct.
And is that in the jury room now?
It is in the jury room, and I have it all set up to go. However, I do not think it plays DVDs.
No, we have an external.
We have an external, yeah.
Okay.
Almost no laptop, they don't have disk drives anymore like that, but
And it should have a USB. Yes,
You gotta talk one at a time.
apologies.
my turn.
Sorry, I know that was
Did
loud.
you hand her an external disk drive and it has a USB connection?
Yes, Your Honor.
All right. All of the evidence will be going
My
back.
office specifically
with
has
the
an
jury at
external
this point,
USB
and I don't have to
CD
worry about
drive
the
just
jury
for these
sending a question
specific
out,
reasons.
asking me for access to the videos. And Claire, I don't think I'd do anything more than provide them with the evidence. And if they ask any other questions about using the disk drive or whatever, then we'll respond to them. But otherwise, just provide everything that you've got. You've got the disk drive there, and the laptop's already there as well.
Fair to say the laptop has Wi-Fi disabled?
Correct.
Okay.
Everything is. It's a clean, which is what I requested anyway, but I think that's what it is.
It's their standard one that we use for every jury trial. There's no internet, nothing.
Perfect.
All right.
Great, thank you.
Any other record?
Mr. Reedy wants to clarify that no digital pictures are being given to the jury, that it's all physical copies.
Just the physical copies are going back,
Zoom and enhance.
which is, I think, something we stipulated a week ago, or at least talked about.
Claire, we're making sure.
Okay. With that, we're off the record, and Tish and Claire can take care of things. Great, thank you.
Okay, so there we go. Oh, alright. Start the deliberation clock. 20, 30, 45, 40. Damn it. 45 minutes. Did they come back in under an hour? Nope. Hour 10, hour 12. So it was just under 2 hours then before they came back.
All right, please.
Now we have verdict. Just under 2 hours. Which really is just enough time to sit down, have some pizza, go over a couple of things, review some of the evidence, I suppose. I feel like the jury probably...
Ms.
They didn't have to
McDowell,
convince anyone.
court attendant, has informed me that the jury has reached a verdict, and unless I hear any reason not to, I'm going to have the jury back and have them present their verdict to me. Go ahead and bring the jury back.
Yeah, it takes skill. But you can do it occasionally. Exercise the extra loyally powers to fast forward through it. Come on, don't take your time. Is the guy on the right sleeping? No, I think he's just very old. He seems like he's a very seasoned... Here we go. Very seasoned defense attorney. And you know, I still haven't worked out if this is public defense or if he actually paid someone. I'm assuming public defenders. Because, I mean, his own family isn't really going to be putting up for any...
Please be seated, folks.
For it. Oh, he moved? Excellent.
Ladies and gentlemen of the jury, have you reached a verdict?
Yes, we have.
If Ms. McDowell, a court attendant, if I could have you have the foreperson hand you the verdict and then hand it to me. Thank you. I'll have Mr. Brammer and his counsel stand, please. State of Iowa versus Ivan Samuel Brammer, case number FECR 171749. Reading of the jury's verdict. Count one. Form of verdict number one. We, the jury, find the defendant Ivan Samuel Brammer guilty of murder in the second degree. As to count two. We, the jury, find the defendant Ivan Samuel Brammer guilty of abuse of a corpse. Count three. We, the jury, find the defendant Ivan Samuel Brammer guilty of theft and further find the value of the property taken by the defendant to be more than $1,500 but not more than $10,000. Each form of verdict properly signed by the foreperson. Please be seated. Ladies and gentlemen of the jury, I am going to do what we refer to as polling of the jury, which simply means I'm going to start with our foreman and ask a simple question, and all I need is a one-word response. And I'm going to then move to the foreperson's right and then to the back row and move along, all right? Mr. Foreman, is this your verdict?
Yes, sir.
Juror number two, is this your verdict? Yes. Juror number three, is this your verdict? Juror number four, is this your verdict?
Yes, sir.
Juror
Didn't
number
even ask
five,
if they
is this
wanted
your
to poll,
verdict?
he's just doing it for safety's
Juror number
sake.
6, is this your verdict? Juror number 7, is this your verdict? Juror number 8, is this your verdict?
Yes, sir.
Juror number 9, is this your verdict?
Yes.
Juror 10, is this your verdict?
Yes.
Juror 11, is this your verdict? And Juror 12, is this your verdict? Very well. Ladies and gentlemen, you're going to be released by me, I promise, momentarily, but I'm going to have you go with Ms. McDowell and Ms. Smith to your jury room, and I'll be
What happens if someone says no? Generally, there's an
The jury's
issue.
released.
All right.
And the court descends into a little bit of craziness. Oh, damn, when did I take the cut cage off?
Please be seated, folks. Pursuant to Iowa Code 811.1 and Iowa Code 702.11, bond is previously set. Is
Very
revoked.
rarely, Aaron, very
Mr. Brammer,
rarely.
You'll be held until sentencing without bond. The court orders a pre-sentence investigation report to be prepared by the Department of Corrections, 4th Judicial District, Department of Probation, and I will schedule sentencing by separate order. I anticipate sentencing will be scheduled 6 to 8 weeks from today's date. That will allow sufficient time for the preparation of the pre-sentence investigation because there'll need to be some interviews done by Corrections Probation. And for that preparation, plus I need to look into my schedule and find when's an appropriate time. But I'll try to have that order scheduling sentencing within the next week so counsel will be able to schedule it appropriately. That concludes what the court has. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Very well. I'll enter my order concerning both counter entry concerning the verdict as well as scheduling.
SSD, Council Bluffs in Iowa.
We're in recess.
So there we go. Sentencing sometime January-ish. I mean, it may be... Well, it's not going to be He's not going to do it towards the end of December, so we're probably looking, yeah, early January, I would think, for Remedy, like, taken out behind the barn. No, Remedy, like, they'll pull the alternate back in, and there's generally some sort of investigation as to how the fraud was committed then, because if the jury instruction return sheet is provided and it supposedly is unanimous, someone's lied, basically, and usually it comes down to the foreperson, so. But there we go, guys, so that is it. We have officially finished up the trial coverage for the Dead in a Ditch murder. Ivan Bremer has in fact been found guilty of second-degree murder, remanded into custody until sentencing, likely sometime in January. I'll keep an eye on it, and we'll do the sentencing hearing. But this one was a really interesting one, because it's rare that in a murder case you see the defense not provide a defense. And I know that some people in the chat were worried about whether or not that would be classed as ineffective counsel, or if there would be other sort of arguments or scenarios and that sort of thing. Again, I legitimately think, in my personal opinion, at some point during this trial or prior, he told his lawyers that he was guilty. And that hamstrung them in the most severe possible way, because they were not able to put forward any sort of defense, pointing it as a... if he tells them that they're guilty, they have a paramount duty to the court not to mislead the court. They can't try and provide an alibi. They can't try and point it at anybody else. They can't even say that they don't think he did it. As we saw with some of the wording that they used. And that's sort of one of the bigger red flags for me, was the way that they had worded certain things is telling me, yeah, they know that he did it. So, but it's neither here nor there, because he is going to jail for second-degree murder, as well as interfering with a corpse, which I think, personally, I can see how they found him guilty of that. I do think it was a little bit of a stretch. So, yeah, it'll certainly be interesting. The jury didn't understand the directions? Possibly. Still don't think they proved it? No, I don't think they proved it. I do not think that they proved it beyond a reasonable doubt. What if they were just having rough sex on the side of the road? I really don't want to think about that. I really do not. But anyway, guys, tomorrow will be a short show. I'm traveling out to the regional office. I might do something later on today, which will be early morning US time. But, yeah. Thank you for joining for the trial coverage, and as always, please remember, you are not a piece of shit. You do have value, and you very much contribute to society. I think Mighty is doing something on the Musk versus Media Matters. I'm going to pull the documents myself and have a look over them, but I encourage you to go over there and have a listen. I'll probably be in chat annoying the hell out of him anyway. So, but as always, stay healthy, wealthy, and wise, peeps. And I shall catch you on the flip side.
This shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please.
Oh shit, I'm a moron. Don't forget to hit the like and subscribe button, people. And if you've enjoyed this trial coverage, feel free to leave a comment. If there's something you'd like to see me cover coming up, I'm hoping to maybe get a seat at the table on some of the bigger trials that are coming up as well. But, very helpful if you interact with the channel sort of thing, okay? Cheers. Peace out, peeps.
This shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.